excluded from saying suspicious transactions.
Then what's your recommendation, or how do they convey to the jury that they had a concern? Is it, I thought they were illegal, I thought it was fraud, I thought it was suspicious? I mean, from my perspective, fraud would be a lot harsher than suspicious. I mean, a lot of things can be suspicious for a variety of things that wouldn't rise to the level of being a theft. For example, you know, if any one of us has probably traveled to another state, and if you start using your debit or credit card, you're going to get that call from the fraud department of your banking institution. They're doing their due diligence, say, we're a little concerned, these are suspicious, we're concerned they're fraudulent. You say, nope, I made all of these. So, I mean, this is some common vernacular, I think, that's just part of our everyday life nowadays. So how do I balance that out? And if I preclude anyone from saying suspicious, what do they say?
I think that, you know, that's a good point that the court makes. I would say that the biggest concern we have really is with this massive chart that's going to be produced and shown in court that has got line after line, and the biggest part of every line is suspicious transaction. So, you know, at a minimum, that we would ask that be blacked out. They can talk about, these are the transactions we reviewed, these were ones we were concerned about, we looked into them, but the word suspicious again and again and again
Might be prejudicial.
I think it's overly prejudicial, yes.
I presume once we get to closings, if they want to use a chart, and if that's what they want to label it and argue to the jury, there would be no objection to that.
That's true.
All right, what's the state's response then?
Yeah, I think you've hit it on the head, a lot of the terms that we're talking about here. I think suspicious, as laid out in our motion opposing this, it's a relatively tame version of events to describe these transactions. As we noted, we could have labeled these as criminal or fraudulent, and as you noted correctly, in our opinion, all of these transactions, it's whether they amount to theft, not whether or not they're suspicious in nature. So that, I don't think that goes to the ultimate question here. Additionally, frankly, the state I'd be asking the defense what exhibit she's actually talking about that lists all these suspicious transactions that we're talking about, because we're trying to rack our brains about that and we don't have anything off the top of our head.
You don't have some type of compilation or summary exhibit or chart that you plan to use?
Not with the word suspicious transaction.
Not with suspicious transactions labeled and everything.
Okay.
And if we do, I think that's something going forward we can address at the time of introducing that exhibit, not a blanket statement for all these witnesses.
So obviously, I don't know all the evidence, right? Haven't heard it, haven't seen it yet. The parties are intimately familiar with it. I can envision a number of scenarios where a witness might use the word suspicious transaction. I am concerned about getting to the point where it's over and over and over again. I think when we get to that repetition, there is a concern and whether it's unfairly prejudicial. And Attorney Kukler corrected me because she said, well, I think it's unfairly prejudicial because that's the standard. I mean, all sorts of evidence can be prejudicial. We know that. It's whether there's unfair prejudice to the defendant. So just give me just a very brief offer of proof as to how many witnesses you think we're talking about, and whether there's, you know, my concern for cumulative reference to suspicious is founded at all.
Judge, just because they're mostly my witnesses, I'll give the offer of proof, even though Attorney Crawford is arguing this, if that's okay with everyone.
Sure, go ahead.
So I believe Anthony Poza will reference that he asked Ms. Kurczewski at some point for receipts related to the probate, as he's put it to me, because he felt something was off. He's never used the exact term suspicious, but as a means of explaining why he even asked for receipts, he describes it as just feeling something wasn't right or something was off. Attorney Beth Taylor, who's been doing probate work for 25 years, is going to testify that when she looked at the final account statement on that probate account, she saw it as a red flag that a 67-year-old woman would have $100,000 plus of credit card debt. She doesn't see that ever, if not very seldom, in her 25-year career. And then it'll be Detective Plennis primarily going through all the financial statements, really talking about the patterns of life between Lynn Hernan and Ms. Kurczewski and how those were fairly different from one another, both geographically, spending-wise, as well as amount spent and things of that nature, and frequency of credit card use. I don't know that he and I will ever really get into a back and forth about this is a suspicious transaction and this is a suspicious. I don't think we're going to belabor any points. I think that may come up organically in terms of why he was paying attention to these types of transactions, but I don't think it's going to be something that's belabored where he and I are just filling the court transcript up with the term suspicious transactions. But I think we should have the freedom to describe, primarily through Detective Plennis, that this is what he's looking for in his investigation as a detective, is for suspicious things. Ms. Kurczewski was a suspect, and so we are looking for suspicious things. Alternatively, I don't know what a detective is supposed to say aside from, I was just looking at numbers and here's what I had.
Were you planning at all in your opening statement to describe these as suspicious transaction? And if so, is it a one or two time reference, or were you going to
I mean, in my
dig into that?
In my opening, I really talked mostly about how we were going to prove that these are thefts and not simply suspicious transactions, but that we are going to prove that Ms. Kurczewski stole this money from both Lynn Hernan and then later her estate. I'll say right now, just because it might come up, there's several references to the lies that we are going to prove were lies on the part of Ms. Kurczewski. That is, I would say, the bulk of my opening statement. But the word suspicious transaction is not one time in my opening PowerPoint, nor do I intend on, again, belaboring that specific quotation.
Attorney Kukler, because you brought this motion, is there a particular witness, a police report, or some other piece of evidence that this phrase, you reviewed and that's why you filed the motion, or was it just generally your belief that this was how the state would refer to these transactions?
Thank you. No, it was because I believe that Detective Plennis was going to introduce a chart that was in discovery that is filled with a chart that we received from the state, a ledger, a spreadsheet, I guess it would be the best word for it. It's a spreadsheet, and it's filled with line after line after line of the word suspicious transaction. If the state's indicating that they don't have any such exhibit that they're planning to introduce, then problem solved. But I assumed it was going to be used.
Understood. All right. Attorney Sitzberger?
Judge, I don't believe any of our exhibits that we turned over to defense yesterday on the flash drive have anything labeled as suspicious transaction. In some of the earliest discovery, there was an Excel spreadsheet with the original detective sort of summary of the accounts very early on that may have said that, but if the defense can point to a specific exhibit number that we've turned over, I'll certainly take a look at it, but conferring with the entire team, we do not believe any of our trial exhibits label anything, quote, a suspicious transaction.
All right, thank you.
Obviously, Judge, the flash drive was turned over yesterday and our motion was filed in advance of yesterday.
Understood. Obviously, review that. I mean, it's the actual exhibits based on what's in discovery, so I understand why the defense raised this issue. But given the offer of proof from the state and the arguments, I'm going to deny the motion. I will say this. I think similar to an OWI case, Detective Plennis, if he, in his review, considers these to be, if he renders an opinion, let's say, no different than an officer in OWI case, that there was a concern, overall for theft, for suspicious transactions, I think that's fine. I will leave it to the defense if it becomes cumulative to raise an objection. That would be my concern as well. But given what I've heard from the state, that would be, I guess, fair game. It's not going to be overly or unfairly prejudicial to have even lay witnesses talk about things, that something was off, there were red flags, there was a concern. I think all of that is fair game. And if for some reason there is this chart and it materializes, or there's a change in game plan to use an Excel spreadsheet that was in discovery, then of course I'll revisit this. But given what has been stated here today and the arguments, I'll deny that request. Do you want that document, Madam Clerk? That's the 242. All right, then let's take up the motion related to the witness and the request that the witness appear by Zoom. Attorney Kukler, will you be handling this one as well?
Yes, I will be. I think that it's self-explanatory, really. We're asking that one witness be allowed to testify by Zoom. I know I've read the state's objection to it. I would comment that there I understand that they object to it. However, I've had certainly many trials, and just had one 3 weeks ago where we had several physicians testify by Zoom. It went very well. We didn't have any problem. It was a courtroom similar to this with new technology where we could share screens.
Was it a civil or criminal case?
It was a criminal case in St. Croix County with Judge Waterman, and he allowed witnesses to testify by Zoom if they needed to, if they had good reasons, like their health or where they were located. He allowed it.
Did he do any type of instruction to the jury, given the technology?
He did. He did tell the jury every time one was testifying that they were to consider their testimony the same as if they were in the room, that they weren't to give it less or more weight, especially because one of the TVs was large. So they weren't to consider that to be more significant than a person that would be in the courtroom. But he did that each time.
Did any of the witnesses need to be questioned about medical records or documents, and if so, how was that addressed?
So yes, they were, everyone, and we were able to. They had the ability in that courtroom to give us the ability to share our screen. So they would release the screen to us. We could share the screen, whichever attorney was doing the questioning, and it worked fine.
We have that ability.
Okay.
I've done that before.
So this doctor has asked for that consideration. I'm making the request on her behalf.
And where would she testify from if I allow this?
She would testify from her office.
And have you been able to confirm if that's private, meaning she can close the door, no one else would have access?
I didn't confirm it, but I can make sure and instruct the witness, as we did in this last trial, that they were to be in a private room with no one else present.
All right, and who will be arguing this for the state?
I will, Your Honor.
Go ahead.
Your Honor, as noted in our response here to the defense's motion, I just think that there's too many variables here for this to go forward via Zoom. Mainly, these a lot of medical records here that are going to be involved. Obviously, we'll be able to pull them up for her potentially, but depending on her location and situation, she could have notes that might be on the side to verify what's actually in front of her could be a problem. I would also note that I think the biggest thing for the state here is the fact that the doctor here is still seeing patients regularly. She's going into work to do this. She's going to church. She's going to the grocery store. She's doing all these things, living a relatively normal life, still wearing a mask and all that. That's no issues. The state would have no issues with that precaution being taken. But it's our position that coming in and testifying, it's not like all these people are going to be coming in here and trying to spread germs to her. There's no different than going to a crowded church or a crowded grocery store. Those are all places that have a lot of people. This is not like the doctor here has ceased going to the outside world or anything like that. So for all the reasons of the complications, I understand that technology is obviously taking a step forward and we're not living in an archaic time here in that regard, but just given the potential for a blow up or something going haywire in that regard, as well as the other issues that I've already addressed, the state would be in opposition here.
Attorney Kukler, as I understand this witness, this is someone who treated the victim at one point.
Correct.
And your direct of that witness, how long do you estimate that will take?
No more than 2 hours.
So fairly detailed in terms of the testimony you hope to elicit.
I'd say no more than 2 hours.
Okay, but what I'm getting at, this isn't just a 5 or 10 minute witness.
No.
Okay. And how long does the state believe their cross will take?
Your Honor, at this point, the state can't give you a number.
You reference the medical records on cross-examination. Are these her own? I mean, the medical records this doctor was part of generating through the course of treatment?
Yes.
Or other medical records that you want to confirm maybe that she's not aware of or something like that?
No, it would be the ones that she helped generate.
So presumably she would have all of those because they're electronic, right?
Correct.
So the statute this court must consider is 807-13. And obviously the defense has made this request. There's an objection by the state. The court can allow such testimony if I find there is good cause for allowing it. And I think good cause can be based on for a variety of reasons. Certainly the health of an individual is something this court needs to be mindful of. A person's compromised immunity would fall underneath that. I'm not at all concerned about the technology. This courtroom was built for these opportunities. I have done everything from having witnesses. We did motion hearings with experts in this particular case last December. I have routinely taken pleas in very serious felony matters by video. I've had victims afforded the opportunity to appear by video. And I don't think it is necessarily my place to second guess this doctor's comfort level in coming to a public building in a courtroom. While I believe that we operate very safely, I've done many, many trials through the pandemic, during, after, and we have done so safely. We take the utmost care and concern for our jurors, for our witnesses. But the fact remains there are people who do not feel comfortable coming into a public place where there is high volume of traffic. Even though this witness stand is pretty isolated, I'm not within 6 feet. They might be within 6 feet of our court reporter, and our jurors would be more than 6 feet away. And I'm obviously referencing 6 feet because that is something we did during the pandemic, and I think even that bubble, if you will, has reduced a bit over time. But she has raised a request through the defense team, Dr. Sema, that is, and although she's seeing patients, I don't have a lot of information. I don't know what other precautions that she takes. I don't know if she sees them by video or not. But I believe that the defense has sufficiently shown that there's good cause based upon the health concerns and the compromised immunity for Dr. Sema to testify by Zoom. I would ask Attorney Kukler that you forward to this court by way of email the language that Judge Waterman used in his case that you were a part of in St. Croix County. I will make available, since this will be by Zoom, each party should bring a computer that can connect to the Zoom so that if you want to share the screen and cross-examine based upon medical records, I will do everything in my power prior to the witness taking the stand and outside the presence of the jury, we will do just a brief colloquy. I will do a brief colloquy with her just to assure that she's in a private room. There's a door, that no one will interrupt her. We will ask her what she has in front of her, what she has access to. If there's a request that she not have access to her electronic records, then I'll take that up at that time or shortly before she testifies. And I would ask, though, that and require that she have the ability to share her screen as well, if in fact she does access something and so that the parties can see it. Now, I realize in a normal way of doing things in the courtroom, that's not on the television, right? And so there's been a request, and so we'll have to think about how we protect the privacy of those records as they relate to the victim. No one's really raised that here today. I know that I can turn off the monitors so that for the time being, only the parties would see it and the court, so that the jurors are not. Obviously, if these are records that you all plan on being part of the file in any event, it may be, as we get closer to this witness, that it's more appropriate. I don't know how long her records are, but it might be more appropriate to have them printed off, since it's her request to testify by Zoom. Then it may also be appropriate, and I would order this, that she print off and have a printed copy and provide a copy to the state and to the defense. That way, I'm also protecting the privacy of those medical records, and they're not being streamed, worldwide. I kind of, as you can tell, this is sort of stream of consciousness, but that just kind of came to me. I thought about it. I'm like, I need to be concerned about that. And so I think what I will do is what I've just outlined is require her to print off all of the records related to Lynn Hernan and to provide copies of that. Yes, do we have them?
We have them, the state has them. They provided them to us.
But there could be something we're not aware of. And so I think in preparation for her testimony, you will need to be in communication with her and confirm that those are the only records she has related to the victim.
Okay.
And then I guess I can dispense with the, I just want to make sure that what she's reviewing, you all have, because that's important. Again, we'll allow the share screen. That's not a problem. We'll just have to think about, I may have to make some rulings ahead of time to the media about not showing the share screen. Keep in mind, it's the jurors would still see it, and even if it's on here, they can take precautions to keep the camera on me or the attorney who's questioning or something like that. So just be thinking about that, and we'll revisit it as we get closer to her testimony. And I will give an instruction before this witness testifies. I'll trust Attorney Kukler will get me that language. I may reach out to Judge Waterman as well, and just, he may have, I'm hoping he has a Word document, and then I can share it with everyone. So I'll do that. Did he do anything else with final instructions regarding that, or just did it at the time of these witnesses?
No, I don't think he did it at the final, but if you're reaching out to him, you can ask. I think only as each one testified.
Any other precautions that he took that I should consider?
No.
Just that brief, I'll call it a cautionary instruction, that's what we would call it, to the jury ahead of time.
Yes.
And then, of course, already addressed how we'll deal with, we'll utilize the Zoom, we'll utilize the share screen. I'll give access to the parties during cross to do that. And then I will just have to either enter an order or modify my trial administration, or just give them a verbal order to the media who's covering that they not broadcast those records. All right, Madam Clerk, so that's 246 document number. Okay. Were there any? Oh, I was probably looking at the state's. Yeah, sorry. Any other requests from the defense?
No, nothing on motions. It was my recollection that we had decided that prior to the jury trial each day that we were going to get a few minutes with Ms. Kurczewski. Do I remember that correctly? That you were going to try to have her brought here a little early, and that
She should be here by 8:15 each day. So if you're here by 8:15, then she will be made available.
okay, great. It did, because she wasn't today.
And today we started at 9, and I know there's other things going on, and I may have thrown them off. It's frankly easier for them, I'm told, the earlier it is than later. So, but I was assured that they would do their very best. Obviously, things can be fluid, and sometimes there's situations in the jail that are out of all of our control that might prevent that. But I think they will do everything that they can to get her here between 8 and 8:15.
Okay, thank you. That's perfect. Nothing else.
Okay. All right, then let's turn to the state's requests. We'll be arguing the request about the testimony and whether it be televised.
I will as well.
Just a note on that, it was not filed under seal. And so if I don't have a request, and if you all don't take the steps to file it as a sealed document, there's nothing I can do. And so I know it's been reported on in the media already, so just so everyone's clear, that was not filed under seal, and it's not under seal at the moment.
I know we attempted to use the temporary seal function on our end. I don't know what happened in that regard, but understood.
All right, go ahead.
Frankly, Your Honor, I think a lot of our concerns are addressed in our motion here. Ultimately, we're not trying to intervene with Ms. Kurczewski's, freedom to have a public trial or anything like that. But our doctors here, as evidenced by our meeting with Dr. B late on Thursday last week, so after that Wednesday motion deadline, she continued to raise concerns to us essentially about the nature of this drug, the prevalence of this drug, and I know that the defense is probably going to disagree with this terminology, but essentially creating a how to kill playbook here. As noted in our motion, this drug is odorless, tasteless. There's very discrete means in which this is given. Actually, there are hospitals have issues with they don't even test for this drug. Certain labs across the country don't test for it. It's a very difficult thing to actually test for, and you have to specifically ask for it at a lot of labs. And frankly, the doctors here came to us and brought up their ethical obligation here to ensure that at least we made the request to the court that we don't amplify this testimony here. We understand that they're going to be reported on in the Journal-Sentinel, you name it, whatever newspaper outlet. Anyone who wants to, they can come in court and watch and report on it live if they want to. But we don't want to give this out to the masses even more than it possibly can already. And again, we're not interfering with anyone who wants to come in here in an open courtroom and watch it personally, or follow a live blog or what have you. They could, even if they want, they could order the transcripts from the testimony of the doctors. But we just don't want to make this easily accessible that can be gone back to time and time again for somebody that might have nefarious reasons to do so. So that's the basis for our request here, Your Honor.
Have you done any type of search on the internet to see how prevalent information is outside the medical community and the concerns raised by Dr. Bidzricki and Dr. Kasinko?
I think a lot of them have to do with that there are occasional cases that are criminal cases that are now popping up with this drug, and just the context behind that. We don't have any, I guess, independent knowledge or internet history about this blowing up on certain forums or anything like that.
Aren't you really asking me to limit public access to this trial?
I would disagree with that. We've done trials for hundreds of years at this point in this country with before court TV. Like I said, we're not asking the court to deny access to anybody who wants to come in person and watch this, or journalists reporting on this. We just don't want the internet, there could be thousands of people watching this at any given moment and getting any ideas for any nefarious reasons.
But everything you've referenced thus far has already been discussed in this courtroom. We had motion hearings, Daubert hearings with these individuals who testified, perhaps not in as much detail, but this is not new information. I mean, poisoning someone by any substance, that's not new information. For God's sakes, you can go out on the internet and Google just about anything. You can learn how to make explosives. It's unfortunate, and I'm sure people follow those plans. And I'm just not so sure the information that you're seeking to protecting isn't already out there. And if you haven't done any search of the internet to even refute that, I think I have to assume that this information is well known and out there. So what says the defense?
Well, it is well known and out there. The state handed me a whole stack of papers yesterday that's new that they want to introduce through Dr. B of her research that she's done on the internet, of articles and newspaper articles, and a homicide in Aurora, Colorado, and one case after another that she's found on the internet that they handed me that they're hoping to be able to introduce. So it is well known out there, not only in their own documents that they handed to me just a day ago, but it's been on Dateline, it's on 2020, they've talked about tetrahydrozoline.
And how is it any different, frankly, than the Mark Jensen case? Just a different substance that was televised fully with no restrictions.
No different.
How is it any different than that, Attorney Crawford?
Your Honor, I don't know if that the poison or what have you is necessarily different, or I frankly didn't really pay attention to the Mark Jensen trial. But I can tell you, the court, just from our jury selection even yesterday, we only had, 10 hands that actually knew about this drug or had heard of this case or anything like that. So I just don't think that we need to amplify the effect that this could possibly have. And I want to go back to your point earlier about the previous motion hearings. I wasn't on this case at that time, but it's my understanding that those motion hearings weren't broadcasted on court TV. So
No, they were live streamed.
Right, but
Well, you can't watch them today. They were live streamed.
Who's watching the Wisconsin court access live streams as opposed to court TV? I just think there's a completely different audience that we're addressing here.
I disagree with that because they were live streamed and anyone in the world could watch those. I utilized the court streaming service, what we call Daycast, and so there's not a link to that anymore, but that was available to everyone. I'm going to deny this request. I see no reason to limit public access the way that the state is requesting me to do so. This is a case that's been televised, that's captured media attention really from the beginning. We did have the Daubert hearings where both Dr. Bidzricki and Dr. Kasinko testified. We also had Mr. Spiller testify as well, where, again, may not have been in depth because of the nature of those hearings, although they were pretty lengthy. And it may not be, what I'm trying to say is I anticipate that their testimony will be longer and more in depth. There is nothing, special about tetrahydrozoline poisoning and an allegation of it that would cause this court any concern. I appreciate that the folks in the medical profession feel they have an ethical obligation to, raise the issue. But this court has made a decision that it would be televised based upon the request that I received from Court TV. I would say almost all of the proceedings in this case have been televised, except for jury selection and frankly the motion hearing we had last week. But most of them have been where all of these things have been discussed. Frankly, the criminal complaint has been reported on in detail. And so all of that is public. The Supreme Court rule that's cited by the state does not apply in this particular situation. The state acknowledges that. So I'm going to deny that request. Madam Clerk, that's document 247. Any other requests other than the letter that was filed regarding the prior convictions of witnesses?
The state does want to address briefly, defense did provide us a copy of their exhibits, which we obviously appreciate. In that, there are a couple exhibits that we just want to make sure that are addressed ahead of time.
I'm not going to do that right now. I don't have anything in front of me. I'm not on notice. I don't even know what they are and haven't pulled them out. Let's talk about those since it's not a new issue, even though the letter was filed yesterday. At least I have a question regarding the prior convictions. I know at one point, it's at least my recollection, that I ordered the parties to meet and confer ahead of the previously scheduled trial. I don't know if that ever happened because it ultimately was adjourned, but have the parties met and conferred regarding prior convictions for witnesses?
No.
All right, then before I take that up, I'm going to require the parties to meet and confer. And then you can limit, maybe there's stipulations, but you can limit the issues for the court. I don't need another filing on that. I'll certainly work off of the October 23 letter. Does the defense know if there's any other? Well, look at this list and make sure you tell me if there's someone not on the list that you believe needs to be addressed. What I would say is if there's concern about defense exhibits, obviously we have a whole state's case to present first. Please meet and confer. I expect the parties to do that. Even if you can't reach an agreement, sometimes clarification can be found, agreements can be reached, but I think it's important. I'm a big proponent of due process. You all know that. If the last 2 weeks haven't shown that, then no one's paying attention. So notice to the court and to the other side of the issues that you're asking me to address outside the presence of the jury and ahead of time. We need to follow those dictates. I understand that as things come up during the trial and there's objections, that's different, but this is ahead of time, and so I want to be the most prepared that I can be, and I've often found that if you meet and confer, that helps resolve the issues. I don't think there's anything else we need to do just yet this morning, but I'll ask the parties, is there anything else from the state?
No.
From the defense?
No, thank you.
All right, well, you will have lots of time this morning to meet and confer regarding the witnesses. It's 9:53. I'm having the jury report at noon. Oh, that reminds me, I do want to make a record. We were after court, juror number 29 indicated to the civilian jury bailiffs that he was not going to come. I've already taken steps that if he is not here at 12:05, they can go find him. This is an individual based upon the jury questionnaire that indicated they might have a hardship. I asked 4 very pointed questions at the end of jury selection where no one raised their hand. I give them every opportunity to raise an issue. I don't know why that person and juror number 27 didn't as well, but I take these things very seriously. I want you all to be aware of that so you can pay attention and watch these jurors. We'll just keep plugging along and address anything else that comes up. I'm just giving you this information. I'm not taking any steps at this time other than I'll make sure we have all 16 here when we begin. I'm going to bump up our start time to 12:30 so that we can go through the letter and the prior records of people so we can get that out of the way. So I'll be stepping off the bench. Obviously the cameras and the microphones will be off. If you all want to meet and confer and hash this out and have Ms. Kurczewski available for that, please do so. And we'll get that taken care of before we start, okay?
Could I raise an issue?
Sure.
Thank you. Are you going to say anything to jurors 27 and 29 today?
I haven't decided that yet. I am thinking about that. I may bring them in, just the 2 of them, and talk to them about how this is so important. This is their civic duty. They had every opportunity to raise that issue. They did not. I expect them to be here. And if for some reason we do not get a hold of juror number 29, I have some options available at that point. I wanted you all to have that information, and certainly I'm willing to talk to them as well. I want to kind of wait and see how it goes today. I mean, as they say, a day can make a difference, and maybe they just it's like their initial reaction, they're upset, but they realize, hey, this is important and I need to be here. So we'll just take a wait and see approach.
All right, thank you. And I wasn't sure whether the court swore in the jury yesterday.
Nope, I have to swear them in when they come in.
Okay, all right.
Yeah, I'll do that. I'm a little strategic on that. I wanted to make sure, but yeah, Teresa left me a very nice note. Have Teresa swear in jurors, so we have to do the second oath. All right, thank you, everyone. We are in recess. We'll see you back here at 12:30. believe we have all the jurors left. Yep, he should have a, yep, either side's fine. All right, good afternoon, everyone. I will call State of Wisconsin versus Jessy Kurczewski, 21 CF 885. May I have the appearances, please?
Abby Nikolai, Randy Sitzberger, and JJ Crawford appearing for the state.
Donna Kukler and Pablo Galaviz appearing with Ms. Kurczewski. Good afternoon.
All right, good afternoon. Did the parties have an opportunity to meet and confer regarding the state's October 23 letter and prior convictions for witnesses?
Yes.
We did,
Are there any agreements?
yes. We reached agreements on every one of them.
All right, who would like to put that on the record for me then? And I have it in front of me, so if we just follow that, and I know they're all under one, so, or, well, some are under one, some are under two, so just say 1A, et cetera, and then I'll just take some notes.
Okay, so number 4, we have agreed on 0. And everyone else is 0 on that page. Moving to the next page, number 17, we've agreed on 2. And on
I'm
number
sorry, you said 17 as 2?
yes. And number 20 has 5. 21 has 0. 22 has 1. Oh, sorry, and then on the supplement,
Thank you, I was gonna say there's the second person.
the supplement, number 2 on the supplement, AR, we have agreed on 15.
Thank you. Is that all accurate, Attorney Nikolai?
Yes, it is, Judge.
All right, great, thank you. I've made some notes on that, so I'll keep those handy. And for whomever calls that particular witness with a prior record, it's that party's responsibility to advise the person of the number of prior convictions if they are asked regarding that.
Understood.
Yes.
All right, then we have everyone in the jury room, and also want to provide just a bit of information. When juror number 28 arrived today, he approached Monica Paz and indicated he now recognizes a name of one of the witnesses, that being John Friett. He indicated he only knew this person as Mr. Friett, and that Mr. Friett's son, Michael, is his boss. So I wanted to provide that information that was provided. And if obviously, throughout questioning, they were asked multiple times about knowledge of this case, and I'd have to look at my notes, but I'm not sure what this witness's answer was, but if in your review of your notes, you believe some questioning of the juror outside the presence of the other jurors is needed, just let me know and we can do that at an appropriate time. All right, anything else we need to address prior to bringing in the jurors to be sworn, and then for instructions and then opening statements from the state?
Judge, you did ask us to work together on the state's concerns about defense exhibits. In doing so this morning, the primary concern of the state was possibly labeling of any witness as an alcoholic, and the defense indicated they are not going to be referring to Lynn Hernan as an alcoholic in opening statements.
Okay, thank you. How about from the defense?
I have no response, Judge.
Any other issues or
Nope.
issue you wish the court to address before we bring the jury out?
No, Judge, thank you.
Okay.
One
very-
other thing, Judge, I do want to bring up the question about were you going to bring in jurors 27 and 29 so we could hear a
Not
little
at this
bit?
time, they're here. No one was needed to be picked up, so at this time, no. I don't want to highlight anything or single them out in any way. Like I said, I hope they just come, and maybe it was just a moment of frustration. If it becomes an issue going forward, or you notice something that would require my attention, let me know. Thank you. All right, Madam Clerk, go ahead.
Judge, I can't see Ms. Kukler with this podium. I don't know if it could be moved up more towards the roll. Yeah.
Yes, closer to the,
Oh, yeah, that's perfect.
will you be able to see Attorney Sitzberger then?
Absolutely, yeah.
Okay,
Thank you.
thank you, Lori.
Yeah, I think we do have an issue, Judge.
Can you tell them to hold off, please, Madam Clerk?
Sure.
Give me a second.
We do need to look at that juror a little bit closer, number 28.
Hold on, I want to make sure that. Yeah, I know. Tell them that they know to wait.
Yeah, they're waiting.
Okay. Why is that?
Because that's family of the deceased, John Friott.
Right, but this person said they only recognize the name because Mr. Fryett's son is his boss.
Right.
But he did, unless you can tell me, he indicated he had heard about this case.
That's why I wanted a minute to look at it.
Go ahead, you can look at it, but
Thank you.
unless he answered that question. Do you have the questionnaires? Handy? Can you grab me your number 28, please?
George, are we off the record?
No, we're still on. I'm just waiting for Madam Clerk to grab me the jury questionnaire for number 28. I'm not seeing anything in the questionnaire that would help answer that.
No, although in the questionnaire, I can see that this particular juror is actually vice president of the company, so presumably his boss is the president. So it's a little different than just, you know, some boss at a place.
All right, I'll bring him out and we can question him on whether he has any information about this case or have we been able to confirm that
And
the witness's son is Michael? We know? All right,
And
we'll
I
ask.
also can see in my notes that when the jurors were asked if they knew other people, juror 28 was one person that somebody knew.
Right,
on the
we're not gonna
panel.
revisit any of that. We're simply gonna ask about this new information.
Okay, I thought you wanted to know about our notes. I understand that.
Oh, all right. No, I was just looking to see if the notes had anything specific. Right over there. Right on the end is fine. You can sit back there, it's fine. Yeah. Good afternoon, sir.
Hello,
Just a couple of questions, just confirming you are juror number 28.
correct.
All right. You approached, I believe it was Monica Paz today, to advise her that upon reflection, you recognized one of the names referenced as a witness,
Correct.
and that's John Fryatt,
Correct.
and you believe that you know his son.
I do know his son.
All right.
I
Go
work
ahead.
for the prospect companies. Mike is my superior,
All right.
and John, oh, sorry.
And have you met John Fryatt?
Maybe once at our company.
Have you ever overheard or spoke directly with your boss about this case?
No,
Had you heard about this case prior to coming in for jury service?
no,
Anything about your work relationship, knowing that someone you know has a relative who may be a witness that would impact your ability to be fair and impartial in this case?
I just know, I'm very close with Mike and our leadership team. And so, I know Mike has spoke very, very highly about his father. He's not spoke about any cases, but I know, you know, I think very highly of their family. And so, that weighs in on me trying to be an impartial juror.
Sure, you understand you'd have to make a credibility determination regarding all of the witnesses.
Correct.
And whatever your opinions or feelings about them as a family, you would need to make your determinations based only on what is presented in the courtroom, the law as the court defines it for you. Do you understand that?
Yes.
And would you be able to do that?
I would hope so.
All right, any questions from the state?
No.
How about from the defense?
Yes, I do. Thank you, Juror 28. If you were then to learn during the course of this trial that your boss, Mike, is related to the deceased in this case, do you think that that might affect your ability to be fair in this case?
Yeah, that would have an impact because he's like a family member to me.
Thank you. That's all I have, Judge.
Sir, are you able to set your personal feelings and opinions aside and make a decision in this case based upon the evidence presented in the courtroom and the law as the court defines it for you?
I would hope so.
Thank you. You can take them back and we'll let you know when we're ready. All right, any requests from the parties at this time, from the state,
No.
from the defense?
Yes, we're asked that he be removed from the panel. His boss, who is like family to him, is family of Lynn Hernan. His boss is related to Lynn.
It's not a statutory bias, obviously. He is not related by blood or marriage to a victim. He did testify or provided information today that his boss, someone he has a good relationship with, on leadership with, and knows that this individual, his boss, has spoken highly of a witness in this case. It is true that I don't know the relationship, someone will have to remind me again, between the witness and the deceased. How close are they?
John Fried is a cousin of Lynn Hernan.
Do we know to what degree?
First cousin,
First cousin?
yes.
Do you believe that to be accurate, Attorney Nicolai?
I don't know what level cousin John Fried is to Lynn Hernan. What I do know is that the state doesn't anticipate calling John Fried, and we certainly did not anticipate eliciting any testimony about the familial relationship through any other witnesses. So I think that this juror did not need to be told that there was any relation but nonetheless, the state does not believe that would come in to the evidence portion in this case at this time.
All right, given that additional information, I'm not going to excuse him at this time. He does have additional information regarding a familial relationship. And at an appropriate time, I will remind him and all jurors that any information, they learn, even through voir dire, if it's not presented as testimony or evidence, should not be considered by them in any way. And if need be, I can certainly revisit this at the time when all evidence is closed, closing arguments and closing instructions have taken place, and this court must address alternate jurors. But at this point, he has not indicated he's unable or unwilling, and there's been no bias that has been established, and he'll remain on the jury. All right. We'll bring them out and we'll commence with instructions.
All rise for the jury.
And I'll have my jurors remain standing because you're going to get an oath. So rather than have you sit and stand back up. All right, thank you. Please be seated. Ladies and gentlemen, of the jury. If you would remain standing, raise your right hand. My clerk, Teresa, will swear you in.
Do you swear that you will well and truly try the issues joined in this action now before the court, and a true verdict to give according to the law and evidence offered in court, unless sooner discharged by the court, so help you God?
Thank you.
Thank you.
Thank you, everyone. Please have a seat. Before the trial begins, there are certain instructions you should have to better understand your functions as a juror and how you should conduct yourself during the trial. Your duty is to decide the case based only on the evidence presented at trial and the law given to you by the court. Anything you may see or hear outside the courtroom is not evidence. Do not let any personal feelings about race, religion, national origin, sex, or age affect your consideration of the evidence. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging, or social networking sites to send or receive any information about this case or your experience as a juror. We will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the lawyers. If you come in contact with the parties, lawyers, or witnesses, do not speak with them. For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics applications or tools with communication capabilities, to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media, post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes back to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, jurors, are the judges of the credibility of the witnesses and the weight of the evidence. You are not required to, but you may take notes during this trial, except during the opening statements and closing arguments. The court will provide you with materials. In taking notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and testimony introduced during the trial. During the course of a trial, the attorneys may refer to or use police reports with witnesses. Normally, these police reports will not be provided to you. If you are not provided with a police report, you should use your collective memory regarding any reference to police reports. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial. The witness's conduct, appearance, and demeanor on the witness stand. The clearness or lack of clearness of the witness's recollections. The opportunity the witness had for observing and for knowing the matters the witness testified about. The reasonableness of the witness's testimony. The apparent intelligence of the witness. Bias or prejudice, if any has been shown. Possible motives for falsifying testimony. And all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. There's no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. The first count of the information charges that Jessy R. Kurczewski, on or about Wednesday, October 3 of 2018, at N16W26543 Meadowgrass Circle in the city of Pewaukee, Waukesha County, Wisconsin, did cause the death of Lynn Hernan with intent to kill that person, contrary to Section 940.01, sub 1, sub A of the Wisconsin statutes. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. 1. The defendant caused the death of Lynn Hernan. Cause means that the defendant's act was a substantial factor in producing the death. 2. The defendant acted with the intent to kill Lynn Hernan. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that her conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act was committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reasoning for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Lynn Hernan with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The second count of the information charges that Jessy R. Kurczewski, between approximately January 1 of 2016 and October 3 of 2018 at N16 W26543 Meadowgrass Circle, number A, in the city of Pewaukee, Waukesha County, Wisconsin, did intentionally transfer movable property of Lynn Hernan having a value that exceeds $100,000 without consent and with intent to permanently deprive the owner of possession of the property, contrary to Section 943.20 sub 1 sub A of the Wisconsin statutes. Theft, as defined in Section 943.20 sub 1 sub A of the Criminal Code of Wisconsin, is committed by one who intentionally transfers movable property of another without consent and with intent to deprive the owner permanently of possession of the property. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. 1. The defendant intentionally transferred movable property of another between January 1 of 2016 and October 3 of 2018. The term intentionally means that the defendant must have had the mental purpose to transfer property. Movable property means property whose physical location can be changed. 2, the owner of the property did not consent to the transfer. 3, the defendant knew that the owner did not consent. And 4, the defendant intended to deprive the owner permanently of the possession of the property. You cannot look into a person's mind to find knowledge and intent. Knowledge and intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge and intent. If you are satisfied beyond a reasonable doubt that all 4 elements of theft have been proved, you should find the defendant guilty. If you are not so satisfied that all 4 elements of theft have been proved, you should find the defendant not guilty. The third count of the information charges that Jessy R. Kurczewski, between approximately October 4 of 2018 and July 9 of 2019, at N16 W26543 Meadowgrass Circle Number A in the city of Pewaukee, Waukesha County, Wisconsin, did intentionally transfer movable property of the estate of Lynn Hernan, to wit, money, having a value greater than $10,000, but does not exceed $100,000, without consent and with intent to permanently deprive the owner of possession of the property, contrary to section 943.20 sub 1 sub A and 3C of the Wisconsin statutes. Theft as defined in section 943.20 sub 1 sub A of the Criminal Code of Wisconsin is committed by one who intentionally transfers movable property of another without consent and with intent to deprive the owner permanently of possession of the property. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present. 1, the defendant intentionally transferred movable property of another between October 4, 2018 and July 9 of 2019. The term intentionally means that the defendant must have had the mental purpose to transfer the property. Movable property means property whose physical location can be changed. 2, the owner of the property did not consent to the transfer. 3, the defendant knew that the owner did not consent. 4, the defendant intended to deprive the owner permanently of possession of the property. You cannot look into a person's mind to find knowledge and intent. Knowledge and intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge and intent. If you are satisfied beyond a reasonable doubt that all 4 elements of theft have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. The lawyers will now make their opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show, so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. Prior to having the state come up, I like to have the jurors just stand for a little bit. Wind change. All right, please be seated.
Is that me? Thank you.
Attorney Sitzberger, you will be using the lapel.
Yes,
All right, you can.
did a sound check, I think.
Do you need the podium at all?
I do not.
And Madam Reporters, you have a good view of everyone? Okay.
All right.
Go ahead.
Thank you, Judge. Good afternoon, everyone. On behalf of the state, I'm going to take this opportunity. It's really our first and only opportunity to thank you all for your attention going forward. We talked a lot yesterday about how long this trial is going to go. That's certainly not lost on us, what we're taking you all away from, and we appreciate it. I want you to know we've all worked hard to organize ourselves and make sure we can go through this as quickly and efficiently as possible over these next few weeks. That being said, there is a lot to unpack in a case like this. While I go through my opening, you're going to see almost two timelines. As I prepared for this, I kept seeing almost two timelines emerging. There's certainly a factual, bare bones timeline of theft, murder, and more theft. But there's this almost overlaid timeline of all of the defendant's lies and deceit on top of that bare bones timeline. That's a little bit tricky to go through and process, but let's start it. So this is Wisconsin versus Jessy Kurczewski. Said otherwise, this is a case of murder, greed, and lies. The judge just read you the 3 counts. Of course, in the law, we call murder intentional homicide, and that's count 1. And it's a homicide or murder of Lynn Hernan. Count 2 is a theft of over $100,000 of Lynn Hernan. And those date ranges, January 1st of 2016 until October 3rd of 2018, really represent the theft while Lynn Hernan was still alive. And then count 3 is yet more theft, more greed, of theft of almost $87,000 from Lynn Hernan's estate from October 4th until July 9th of 2019, after her murder. We all come into court with ideas of what homicide or murder are and what a theft is, and certainly there's legal elements that have to be proved that the judge read to you, and we'll go through a bit more, because as the party that has to prove each of those elements to you, I want to make sure you have a good understanding of what intentional homicide is, not just sort of the classic example of somebody shooting another individual in the head and killing them. It can be many things. In this case, a poisoning. But first, Though I said this is a case against Jessy Kurczewski, murder, greed, and lies, at the heart of this case, what I don't want to be lost on you is this is a case about Lynn Hernon, the victim. So let's see who Lynn Hernon was. Lynn Hernon was an individual with a small but close group of friends. I think you're going to see as the evidence comes in that it was really two distinct groups of friends. On the one side was Miss Kurczewski and her mother, Jennifer Flower. On the other side was these individuals, Keith Lang, Corrine Poza, Jim Kelleher, and Anthony Poza. And you'll hear from many of them. Now, interestingly, Lynn Hernon was also an individual with no children of her own. So she sort of pseudo-adopted her friend, Jennifer Flower's daughter, Jessy Kurczewski, and did the same thing with Corrine Poza's son, Anthony. And you're going to hear that they were named the two beneficiaries of Lynn Hernon's will, or her estate, and we'll get into that a lot as well. Lynn was also a cat lover. That seems like a flippant thing I put on there, but it's actually very important because, and I'm fast forwarding a little bit, but at the very day of October 3rd, when police come and talk to Jessy Kurczewski, they ask her point blank, do you think this could be a suicide? And her answer was, well, yes or no, I don't really know. I don't think Lynn would have left her cats. And that's what Anthony, Jim, and Corrine will also tell you. That Lynn was a person who didn't just love her cats like many people. She loved her cats. She was not going to leave her cats alone to fend for themselves or let somebody else come in and take care of these cats. The cat lover part is actually a very important part to all of this. While she loved cats, hated technology. Didn't own a computer, didn't own a smartphone, used a flip phone sort of when she had to, didn't use email, had no email address of her own, had no way of checking it, didn't know how to check it. When she paid bills, it was with cash or over the phone, making transfers through the bank over the phone, or going in person to a branch and making a payment on a credit card or utility bill or something like that. You're going to see, and we'll get into pattern of life and what that is and what that means. But Lynn was not a person to go online and pay a bill. She was not checking her credit card statements online. She was not checking email. She was doing nothing. Had no computer or any device to access the internet. And frankly, dead at only 62 years old from a tetrahydrozoline poisoning after the defendant gave her a bottle laced with Visine eye drops to drink. So I told you we'd get into the legalities of what is intentional homicide. Right? The judge just read these. I'm not going to go through each part the judge just read you, but I am going to highlight that we have to prove to you that Ms. Kurczewski caused the death of Lynn Hernon. I want to highlight that her act has to be a substantial factor. And certainly here you're going to hear, really in the defendant's own words, that she gave Ms. Hernon a bottle of water that she knew to be filled with Visine eye drops. Second element, that Ms. Kurczewski was aware or intended to kill Lynn Hernon. And that can mean that she was aware or practically certain that her act was going to kill Lynn Hernon. We're going to show you that, again, with the defendant's own statement. And when she's talking to detectives after she's told, because there's many versions of the defendant's statement, and they constantly change as she gathers more information through law enforcement. But ultimately, she admits to giving that bottle with Visine in it for Lynn Hernon to drink. And when the detectives ask her, well, did you know that was going to kill her? She says, I was sick because I knew it could kill her. And you're going to hear that knowing that, Ms. Kurczewski still left Lynn Hernon alone, left her house. In fact, you're going to hear that she didn't spend the day worried about Lynn. She was opening a JCPenney account in Lynn's name that same morning. And she was using other accounts of Lynn to go shopping, do some online shopping, while she knew she had just given Lynn poison. Let's talk about intent. Lynn Hernon's not here to tell you what went on October 3rd, 2018. So you have to look at all of the defendant's acts, words, and statements. That's sort of subcategory 1. And then over here, you have to look at all the facts and circumstances that were going on around October 3rd, 2018 for us to show you that Jessy Kurczewski did intend to kill Lynn Hernon. Again, the judge just read this to you, but it's important. We often hear motive in TV shows and movies. The state always talks about, what was the motive? Here's her motive. we don't have to prove motive to you. That's not something in those two elements. We do have to show intent. We don't have to show motive. As this instruction said, motive is often helpful, and here it's pretty simple. As we go through the financials fairly painstakingly, you're going to see that the access Ms. Kurczewski had to Lynn Hernan allowed her to steal every dollar almost that Lynn Hernan was worth in life. And knowing that she was going to be the personal representative of Lynn Hernan's estate, you're going to see that in or about October 3rd, 2018, Lynn Hernan became worth more dead than alive to Jessy Kurczewski. But it's important to note, intent is not the same as motive. The theft counts really go to that motive, but they're separate crimes. Again, here are the elements, verbatim from what the judge just read to you. I try as best I can in openings to let the jury know what I think your job is really going to boil down to. And so with element 1, that's going to be pretty simple for you. That Jessy Kurczewski intentionally transferred property of Lynn Hernan between January of 2016 and October of 2018. You're going to see, and we're going to focus on 28 checks that were all written off Lynn Hernan's account to Jessy Kurczewski. By her cashing those, that's transferring property. That's just element 1 right there. This wasn't a bank error. This wasn't an, oh my gosh, it went into my account and I don't know who deposited this. This is just transferring property. That's element 1, period. What becomes an issue is elements 2 and 3. Again, did Lynn Hernan consent to those money transfers into the defendant's accounts? So that's kind of 2 and 3 rolled in together. And we'll talk about that going forward. Again, number 4 is going to be easy. I don't think you're going to have to spend much time worried about element 4 because it's going to be clear that the defendant never paid back any dollar amount to Lynn either while she was living, and even though she had access to the estate account as personal representative, she didn't put any money back into the estate that she said, oh, you know, when she died, I owed Lynn $144,000, so let me put that back in the estate. Not a single dollar went back to Lynn Hernan, either alive or dead. So number 4, absolutely, the defendant intended to permanently deprive Lynn Hernan of these monies. So let's talk about that consent. It's the same in count 3, rather quickly, the estate. And this, as Ms. Kurczewski and Anthony Poza were the only 2 beneficiaries of Lynn Hernan's property at that point, really this becomes a theft from Anthony Poza. What should have happened was whatever Lynn Hernan's estate was truly worth gets split down the middle, and Jessy Kurczewski should have gotten half, Anthony Poza should have gotten the other half. Unfortunately, that's not what happened. Again, consent will be an issue. For count 4, that should be transferred, I apologize about that, but the transfer of property in element 1 and the permanently deprive in element 4 will not be an issue. You're going to see numerous cash withdrawals that Ms. Kurczewski made from Lynn's estate account to herself, where she's just taken out thousands of dollars, roughly $50,000 in cash withdrawals from the estate account. Again, never paid back. We're going to talk about an inheritance loan funding, where essentially Ms. Kurczewski made an agreement with a company that said, I'll put up $10,000 of the inheritance I'm supposed to get if you give me $18,700 right now. And she paid that back, and they refunded some of the money. She should have plugged that refund back into the estate. But the point is, she took all of that money out of the estate. She didn't wait for her inheritance to put that up. She didn't pay back any of the money. So we have roughly $50,000 in cash withdrawals. We have this sort of bogus loan fund that she takes for herself out of the estate, never paying anything back. And we have a number of checks again, written to either the defendant's own credit cards, to her mother's apartment rent, or just to cash for herself, to the tune of almost $87,000 out of the estate. Again, I included this again because for theft, just like for the intentional homicide, again, Lynn's not here to tell you what she consented to because she was murdered on October 3rd, 2018. So you have to, as jurors, look at what the defendant was doing around this time. What are all the facts and circumstances surrounding this time frame now of October 4th to July 9th of 2019? So going back to count one, I kind of talked about this. But we have this murder element to this case, right? Murder, greed, and lies. The murder part is that our own medical examiner for Waukesha County has been doing this for roughly 35 years. He's going to come in and tell you that as she did her job in this case, she determined the manner of death in this case to be homicide, and that the cause of death was tetrahydrozoline poisoning. Now, she didn't come to that conclusion lightly. She didn't look at one sheet of paper and look at some autopsy photos and look at some scene photos and say, I got it. This case took a lot of time. This took months and months for Dr. Bidzricki to come to her conclusions. She consulted with Dr. Kasinko, who you'll hear from NMS Labs, regarding tetrahydrozoline in general, effects on the body when it's ingested and not just put in the eyes. Dr. B herself ordered several toxicology reports after the original one. She wanted to see more information, as much as she could get. So she was constantly sending lab work out for more toxicology reports. You'll hear she did her own research. She obviously got to see Lynn's body very close in time to October 3rd. And about that, she'll tell you that in her experience over that 35 years, she thought this death scene looked staged. She's been to a number of drug overdose deaths and the scenes, and she'll tell you that this one struck her as being staged. Because she'll tell you that people who legitimately overdose on drugs and end up killing themselves do not have piles of powder sitting on their chest. They don't have powder and pill fragments up in their hair. They don't have pills laying everywhere. They take everything. There's really nothing usually left behind. And so she'll tell you about her observations and why that stuck out to her as something being off about that initial crime scene. She'll obviously tell you about her autopsy and going through that. But by and large, my point is this was not a quick decision she made to say, oh, it's probably a homicide. Let's see how it plays out. This is diligent, thorough work Dr. Bidzricki did to reach her conclusions of homicide and cause of death being tetrahydrozoline poisoning. And she'll tell you there were other drugs or substances in Lynn's system, many pharmaceuticals, but she's still going to tell you that the overall cause of death was that tetrahydrozoline poisoning, eye drops. We know that the defendant, Ms. Kurczewski, killed Lynn Hernan again because eventually, after her story changes a number of times, she admits to detectives that she knowingly gave Lynn Hernan a bottle filled with Visine. And as you can see, Visine has tetrahydrozoline. They're not synonymous, but when we talk about tetrahydrozoline in this case, we're oftentimes talking about Visine. Again, defendant had the intent to kill Lynn Hernan. This is, again, taken directly from the jury instruction as to what intent means. And there it is again. After admitting that she gave this bottle laced with Visine to Lynn Hernan, she told detectives she knew it could very well kill Lynn. She still left, went shopping, opened other credit cards in Lynn's name while Lynn was dying of poisoning. So again, what are all the acts, words, and statements of the defendant? That kind of leads to my greed portion of this whole trial. As to count two, there's the total figure we're going to show to you, and that's for 28 checks from 2 different bank accounts of Lynn. Over $144,000 taken in about a 2 to 2.5 year span of time. What you'll also see in that time is the defendant was getting paychecks direct deposited into her account. So you'll be able to see exactly what legitimate income she was making from her job when she was unemployed and not making any legitimate income from a job. And over this same span of time, January 1st of 2016 to October 3rd, 2018, her total earnings through jobs at various dental offices was right around $49,000. Now, you're going to see that she absolutely needed to have this $144,000 because when we go through all of Ms. Kurczewski's credit cards, bank statements, spendings, you'll see that in that same time span, 2.5, almost 3 years, her earnings were $49,000, her total expenditures over $500,000. You're also going to see that on these 28 checks. I'm sorry, first of all, this doesn't count. This $144,000 figure does not count all of Lynn's credit cards suddenly being maxed out and over their limit. It doesn't count a $30,000 loan that Ms. Kurczewski took out in Lynn Hernan's name after altering bank documents. We've lost the TV. There we go. Thank you. All right. So, bottom line, by October of 2018, an account of Lynn Hernan's, which from 2014 until spring of 2016 held $250,000. Actually, there's about $500 of interest collected on that in those 2 years. By October of 2018 is down to $87.72. You're going to hear that of that significant chunk gone, Lynn Hernan made two rather large purchases for herself. In 2016, she bought herself a Jeep and paid for that out of this account. And she also bought herself some jewelry. You're going to hear that for much of Lynn Hernan's life, she lived paycheck to paycheck, dollar to dollar, until around 2014 when her mom died and left her $250,000 in inheritance. And so she buys herself a Jeep, and she buys herself some jewelry that she ends up paying. She puts on a credit card, but pays down off this account with her inheritance in it. Beyond that, $134,000, more than half, is all 20 checks written to Jessy Kurczewski. Of those 20 checks from that account, we'll keep going. Of those 20 checks, 19 of them have a very specific purpose written in the memo. Some say Kohn, K-O-H-N, Law Office. Some say Prosper Funding. Some say America Advance. Some say Citibank. The point is that you'll see the money leave Lynn Hernan's account, go into the defendant's account, and never do any amounts leaving Ms. Kurczewski's account go to those purposes. Deceit and greed. There's another account Ms. Hernan had that's down to $52 by October of 2018. Here we are. But that involves 10 checks written to Ms. Kurczewski for another $10,000. That represents that $144,000 figure. Okay, let's catch up here a little bit. And that's another point. Out of these 20 checks, there's a 21st check out of this account that's written to the Jeep dealership for Lynn's Jeep. Other than those 21 checks, not a single check will you see come out of Lynn Hernan's account to anybody else. This was not an account she was using. But Ms. Kurczewski had access, and Ms. Kurczewski knew that Lynn Hernan didn't have internet to easily check these things. Again, none of these amounts are ever paid back in life or in death to Lynn Hernan. So let's talk about patterns of life. I mentioned that before. Very quickly, as we go through with Detective Plennis, all the financial statements, and there's quite a few of them, and again, we'll try our best to work through them efficiently but thoroughly for you. You're going to see patterns of Lynn Hernan emerge, right? I told you that most of her friends will even tell you, and it's substantiated by her financial statements, she was often a person to use cash. Her credit cards were not used very often. But when they were generally at businesses like Pick and Save in Waukesha, Speedway gas stations in Waukesha, things of that nature. When she used her credit cards, they were paid down very quickly. Her credit score was up in the high 700s to low 800s for much of this time span we'll be talking about, January of 16 to October of 18. No online activity, no IP activity is on her accounts until approximately June of 2018, when Lynn's pattern of almost 2 years at that point that we can see starts to look a lot like Ms. Kurczewski's, where now all of a sudden we're seeing Lynn's credit cards being used a lot, balances not being paid down, or maybe just the bare minimum so that interest is piling up. We know that Ms. Kurczewski, as I said, she's earning $49,000 of legitimate income in this time, and she's spending well over $500,000. You're going to see that most of those purchases are ATMs, businesses in West Allis, Hales Corners, and Franklin, specific businesses that were talked to about yesterday, Scotty's Pub and Stallis Palace being two of the most prevalent, but also Potawatomi. And you also see that there's frequent online activity. And Detective Plennis will tell you why that's important for law enforcement to recognize that when somebody's pattern of life switches to another person's pattern of life, what does that mean? What does that overlap? What does that change mean? And finally, defendant's acts, words, and statements. And this is to count 3. Taking advantage of her role as the personal representative of Lynn Hernan's estate to steal over $87,000. Again, you're going to see numerous cash withdrawals. You're going to see checks to her own credit cards, checks to cash, and that inheritance loan funding of $18,700. And that brings us to the lies. And this goes on for a number of slides, and I promise you, I pared these down for opening statements. You're going to hear a number of others as this trial goes. But this is kind of that second timeline I'm talking about that goes back now and sort of lays over the bare bones time work. But in March of 2018, Detective Plennis and I are going to show you and talk a lot about clearly altered bank documents where Ms. Kurczewski changed the name of the account holder to Lynn, changed the yearly earnings, changed any reference to spendings at Stallis Palace and Potawatomi, all to get a $30,000 loan in Lynn Hernan's name, but went in to Jessy Kurczewski's account. You're going to see that it went in on March 8th of 2018. That same day, Jessy Kurczewski adds Lynn Hernan to her bank account as a secondary user, obviously so that this loan in Lynn Hernan's name can go into that account. Furthermore, in spring of 2018, and you're going to hear, and Scott Craig is the former boyfriend of Jessy Kurczewski. He was the boyfriend of Ms. Kurczewski until July 9th of 2019 when she was arrested. He'll tell you that he knew of Lynn, knew who Lynn Hernan was. He thought it was a woman that Jessy Kurczewski helped care for, a family friend of Jessy Kurczewski, but he never met her. And in spring of 2018, Ms. Kurczewski tells her boyfriend, who she's living with, who they've been in a relationship for 3 years, she tells him that Lynn is in a coma at Freighter Hospital. That's sometime in spring of 2018, he remembers. Scott Craig will tell you that he believed on October 3rd, 2018, when Ms. Kurczewski tells him over the phone that Lynn has passed away, Scott Craig believed that Jessy Kurczewski was at Freighter Hospital in Lynn's hospital room. He remembers feeling bad, but ultimately not surprised because he thought this woman had been in a coma for 5 months and that it was sort of a natural outcome. Ms. Kurczewski never came clean to Scott Craig. It wasn't until July of 2019 when detectives show up at his door and tell him that Lynn Hernan did not die in Freighter Hospital. She was not in a coma for 5 months. And you'll hear a jail call between Ms. Kurczewski that she makes to her boyfriend a few days after her arrest, Scott Craig, where he's furious that she lied to him about such a huge thing. And you'll hear her try to say, it's only one thing. It's only one thing. What's the big deal? On October 3rd, as we talked about, she's using Lynn Hernan's credit cards even after giving her this bottle of poison. She's opening up a JCPenney card. She's using that JCPenney card immediately after opening it, about 10:30 in the morning. We move to October 8th of 2018. She goes and picks up Lynn Hernan's jewelry from the medical examiner's office, and within 2 weeks is selling 3 pieces of jewelry to Robert Hack. And what's interesting about this is that Robert Hack makes you declare how long you've owned an item before they're just going to let you sell it, right? They don't want people just taking things that aren't theirs and coming in and selling it and getting the money. Ms. Kurczewski fills out 3 separate forms saying one of these items that she picked up 2 weeks ago, she's owned for 2.5 months. Another one that says she owned it for 3 or 3.5 months. And the third piece she says she has owned for 6 months. Moving to later in October and early November of 2018, you're going to see that there's even more credit card activity for Lynn Hernan's credit cards, weeks after she's dead. In January of 19, here's another big one that involves Scott Craig. He wakes up one day to hear from Ms. Kurczewski, who went out the night before. There's a big text message conversation where she's claiming she feels very sick and thinks she was drugged at the bar last night. She elaborates and she goes on to say, I had to go to the hospital. This is very serious. And she says, in January of 2019, and it's important to know that Dr. Bidzricki had not yet made a determination of the cause of death to be tetrahydrozoline poisoning, and the detectives had not told Ms. Kurczewski what that cause of death was because it hadn't been made yet. And yet here she is telling her boyfriend that she's at the hospital and the doctors had her run tests and that she is found to have been poisoned by tetrahydrozoline. She doesn't say eye drops. She doesn't say Visine. She says they found tetrahydrozoline in my system. She tells her boyfriend that this is serious. This can kill you. In July, fast forward to July 9th of 2019, when detectives now tell Ms. Kurczewski that Lynn died of tetrahydrozoline poisoning, she seems shocked and then says, I didn't even know you could die from that. Months after telling her boyfriend, this is serious, you can die from this. Next, to February of June of 2019, the police will tell you all about how they go through people's phones. They went through Scott Craig's phone, they went through Jessy Kurczewski's phones, they went through some other phones, and they download them. And they're good at getting everything they can, including some deleted things. And lo and behold, on Ms. Kurczewski's phone, between February and June of 2019, they find a number of documents that she deleted from her phone. The subjects are, quote, criminal poisoning, cyanide poisoning, and household poisons. Those all show in the phone download that they were accessed. I mean, somebody opened them on her phone in July of 2018. Moving to April of 2019. Anthony Poza, who I told you earlier, was like sort of an adopted son to Lynn. He's the other beneficiary on the will. So Ms. Kurczewski has to run everything by him, and he has to sign off on things before she can close the estate. He feels like something's off. He doesn't think something's right, and he asks to see receipts. And a few weeks later, Ms. Kurczewski sends him 52 pages of receipts or invoices. Detective Plennis will talk to you at length about how he went through each one of them. Some of our witnesses will be very fast witnesses who will look at a receipt or an invoice that was given to Anthony Poza, and they will tell you this is not our company's invoice at all. This is completely made up. Detective Plennis looked into all the financials. If Ms. Kurczewski claimed to pay off a credit card of Lynn Hernan, Detective Plennis looked at it and found it to be false. Almost all of these 52 pages are completely false documents that were given to Anthony Poza by Ms. Kurczewski. Conveniently, about a month or less after she purchased Adobe Acrobat on one of her credit cards. That will show you. And finally, more lies. When she talks to detectives in both March and July of 2019, her story changes a number of times, and Detective Hoppy is going to tell you all about those. But even on the scene, I told you before, her initial statement to the scene officer, who just said point blank, you called this in, Ms. Kurczewski, you're friends with Lynn Hernan, do you think this could be a suicide? She doesn't say, yes, absolutely. Lynn was suicidal for a long time, and what a tragic ending. She says, I don't know. Yes and no. I don't think she'd leave her cats. In March of 2019, she writes an email to one of the detectives on the case and says in that email she has a hard time believing Lynn would commit suicide. Okay? Now July of 2019, she's arrested. She's told this is a poisoning and that police now know the medical examiner has deemed this a homicide and they don't think it's a suicide. Now, Ms. Kurczewski starts claiming that Lynn was suicidal for months leading up to October of 2018. She still denies helping in any way or knowing anything about Visine many times. Ultimately, then her story changes again. And she says, okay, well, one time I put 2 drops of Visine in a glass of water for her because I just knew that she was drinking Visine. But that's it, that's all. To ultimately stating, again, that quote, she finally gave that water bottle, knowing it had, in the defendant's estimation, 6 bottles of Visine to Lynn Hernan, knowing it could kill her. And walks out of that condo unit, closes the door, and goes shopping on Lynn's dime. And then that leads into a law enforcement goose chase, I'll call it, where Detective Hoppy will tell you, I suspect with some frustration in his voice, about more lies Ms. Kurczewski told law enforcement. Starting with, you guys, there's a recording from Lynn, there's suicide letters, there's all this evidence that'll show I'm not guilty of any of this. There's evidence out there, there's evidence out there. It starts with this storage shed. She says, check a storage shed. Detective Hoppy says, where's the storage shed? And very quickly, Ms. Kurczewski goes, kind of laughing, says, there was never a storage shed. I was going to get a storage shed, never did, but that's what I was going to, but there's no storage shed. So next, she tells Detective Hoppy, we have to check a BMO Harris bank lockbox. And the detectives do, they did before, and they learn that it's empty. There's nothing in there. They also learn that Ms. Kurczewski and her mom, Jennifer Flower, were the last ones to access that bank box, and just so happened to do so on October 4th, 2018, the very day after Lynn died. So when Ms. Kurczewski is telling Detective Hoppy to check the lockbox, she already knows it's empty because she was there and she was the last one there the day after Lynn died. So that doesn't work. So she now changes to say, well, I buried a lot of stuff in Whitnall Park, kind of by the nature center. And Detective Hoppy will tell you that another detective was out there in Whitnall Park with a metal detector and a shovel. They're trying to use video access to have Ms. Kurczewski tell us, where in the world do we find these things? Spoiler alert, they found nothing. There was no magical, mysterious hole at Whitnall Park. Just more lies from Ms. Kurczewski. And finally, in November of 2019, Ms. Kurczewski is removed by the court as personal representative of Lynn's estate, mostly because of this investigation. She takes that and says, well, now there's a real will I have to file. Almost a year to the day, almost, of filing the actual original will that's notarized by two impartial people. Ms. Kurczewski now files a, quote, real will. And wouldn't you believe, it removes Anthony Poza as a beneficiary. You're going to hear from Paul Nowakowski, the Register and Probate of Waukesha County, and you're going to hear from Beth Taylor, an attorney who's done probate work for 25 years. They have never seen somebody file a quote-unquote real will a year after. And they've certainly never heard it being done as a test. Because that's what Ms. Kurczewski says. She says, I filed that will originally, and this was all a test Anthony Poza was supposed to pass. And he failed because he questioned what I spent things on. And lo and behold, she tries to leave herself as the sole beneficiary of what's left of the estate that she stole from. Just more lies. That leads me, and I think this is my second to last slide. But when we look at all those facts and circumstances, when you're talking about what was Ms. Kurczewski's intent, did she have that intent to kill, and what was her knowledge and intent as it related to the theft, remember the instruction says you have to look at all the facts and circumstances. And here they are pretty simply, I think. Between January of 16 and October 3rd of 2018, Ms. Kurczewski was able to steal $144,000 plus from Lynn Hernon while she was still alive. Ms. Kurczewski got it to a point where Lynn Hernon, as of October 8, 2018, lost almost all of that $250,000, right? It was down to $87. Now that she's worth nothing, her credit cards are maxed out, her bank account, one of them is at $87, another one's at $52. She's worth nothing, unfortunately, to Ms. Kurczewski. But her estate is valued at approximately $150,000. And Ms. Kurczewski helps herself to $87,000 of that. Lynn Hernon's murder falls so conveniently for Ms. Kurczewski as to when she could maximize her profit off Lynn Hernon. And this is not a suicide. This was intentional homicide. So I come back to what I told you was the heart of this case, Lynn Hernon. And justice for Lynn Hernon here is 3 guilty verdicts for Jessy Kurczewski. And that's what the state is asking you to return here. Thank you.
We'll take another quick stand break. So please rise before we have the defense come on up. Attorney Galaviz, do you want the lapel so you don't have to worry about the microphone, or?
Anybody need any water?
So you don't get feedback, why don't you hand Madam Clerk the other mic, since you'll have the lapel. The one on the podium, that is. Thank you. when you're ready, Attorney Gallagher.
Jesse, can you hear me? Yeah. I gotta get closer. I wanna see you all. Thank you for being here. This is day 2 and only maybe 15 to go. Hopefully sooner rather than later. As the prosecution says, we're gonna try to get this case done as quick as possible, but not too quick. This case is extremely important to Jessy. And as you sit there, I want you to look at her. She's presumed innocent. As you sit there, right there. And don't ever let that thought leave your mind, that she's presumed innocent. No matter what he just said, when he's throwing all this stuff at the wall, to try for you to find her guilty, she's presumed innocent. And that's the jury instruction the judge just read to you. All defendants are presumed innocent. And if you can reconcile under reasonable hypothesis that she's innocent, you have to, of all the charges. If there's any kind of hypothesis, reasonable hypothesis that she's innocent, you gotta find her not guilty. And I hope you understand that. As you sit here every single day, as you listen to their case, I want you to keep in your mind that she's presumed innocent. And never lose that thought as you hear their witnesses. Because in order to find her guilty, under common sense and logic, which you're allowed to do, your common sense of life's experiences, you're going to have to speculate. And the judge just told you can't do that. You're going to have to guess and speculate what Lynn Hernan thought while all this was going on. And if Lynn Hernan was here today, she would say, "Are you crazy, prosecution? That's my daughter that you have sitting there at that desk over there. That's my daughter. She knew everything that I was doing when I was doing this. I loved her. I loved her. She's my daughter. I've known her since she was 8 or 9 years old. That's how long Lynn knew Jessy, since she was a child. Here's a picture of Lynn and Jessy, a graduation party that Lynn threw for Jessy, high school. And there's more photos of Lynn. See how she's grabbing her in these photos? Look at her, how she's grabbing Jessy. This is my daughter. She's so proud of Jessy. Has her arms around her, a hand on her head. That's who Jessy is to Lynn, her daughter, even though not by blood. And there's more photos. Same photo. Lynn liked jewelry. She liked getting her nails done and her hair done. But she loved that person that she has her arms around. And there's more photos of Lynn and Jessy. Look how she's holding her. This is my daughter. I'm so proud of her. And them not knowing this about Lynn and Jessy, not knowing the dynamics about Lynn and Jessy, maybe in their view of this, doesn't make sense to them why Lynn would give Jessy all this money, why a mother would give their daughter or their son money. And as he said, he's correct. Lynn had two groups of friends. She had Jennifer and Jesse, and then she had Keith, James, Corrine, and Anthony. But the problem was with what he told you is we all have circles in our lives. Circles, where we only keep a few people in our circle. And only these few people that we have in our circle, the people that know our secrets, that we talk to every day and share everything with when we're not feeling good or feeling happiness and sadness. And that was Jennifer and Jesse. She was in Lynn's circle. When Lynn needed help, she called on them. Every single time. When Lynn needed help, she called on Jennifer. Jennifer's like her best friend. And Jesse became her best friend. When Lynn needed to move, in 2009, Jennifer helped her, and Jennifer's boyfriend, Gary Verdon. She didn't call Keith, James, Anthony, or Corrine. Who do you call when you move? Your friends, your closest friends or relatives. That's who she called, Jennifer. When Lynn needed to move into this condo, who did she call? Jennifer and Gary Verdun. She didn't call James, Keith, Corrine, or Anthony. They didn't help her. When Lynn's mother died in 2013, who did she call to help her drive to Madison and help clean up her mother's place and get it ready to sell? Jennifer and Gary. They drove to Madison and helped Lynn clean out her mother's house. She didn't call these four other people. They weren't in her circle, that inner circle. And their documents that they gave us is in the proof. Her bank account, Lynn had all this money in two bank accounts, her checking account and her money market account. Who was on her account with her? Joint. Jennifer. Jennifer Flower. That was her checking account. Jennifer was joint on that account. She loved Jennifer. Her money market account, again, she had a lot of money in the money market account. Who was on that account? Jennifer. When you have a joint account, who do you put on the account again? Your husband? Your wife? Here, Lynn didn't have anybody. She had Jennifer. Jennifer, it's like together. Lynn needed help, Jennifer helped her. When Jennifer needed help, Lynn helped her. When Jesse needed help, Lynn helped her, because that's her daughter. Anthony and Corrine, they didn't need help, they had money. This case, as the state's kind of said, during this time, which doesn't make sense to them, is Lynn was on disability, full disability. She had all this money, and she was receiving food stamps. She was getting full insurance and food stamps during this time, since 2009. And that was real important to Lynn, not to lose that. And you can lose it, depends upon how much money you make, money you have in your accounts. Because you're not supposed to get food stamps and full disability. You're not supposed to get disability and food stamps when you got a lot of money. Because why do we want to pay for somebody who's got a lot of money for their insurance and food stamps? Taxpayers. Lynn was on food stamps until she died with all this money. From the moment she inherited all this money until she died. But this is a case where they see a suicide. Can you give me the next slide? Lynn liked her vodka. And when she died, I'm not saying she's a bad person, she just liked vodka. She also liked Visine. I have no idea why. Why somebody would put Visine in their alcohol or Visine in water. I don't know why people smoke marijuana. I don't know why people do heroin. I don't know why people do cocaine. I don't know why people do fentanyl. I don't get it, but people like doing that. That stuff doesn't make sense to me, why people want to put that in their body. Lynn liked to put Visine in vodka and water. Why? Who knows? I don't know. Like, I don't know why people do heroin and cocaine, but they like doing it. When Lynn passed away, they talk about, and I want you to hold him to this prosecutor, when he came up here and said, the tetrahydrozoline, the Visine killed Lynn. You hold him to that when he came up here, that's what killed her. You know, to this day, no one's ever died from Visine, ever, on planet Earth. No one, not one person's ever died from Visine, tetrahydrozoline poisoning. It's never happened. And I learned during this case, it's kind of like marijuana. You know, you can smoke blunt after blunt after blunt after blunt after blunt, and it can't kill you. The ingredients of marijuana. And I learned it through this case. That you can smoke all day, every day, marijuana, it can't kill you. Apparently something with your body. And it's like that with Visine. It can't kill you.
Judge, I'm going to object. That's not what any of the evidence is going to come in to say.
Attorney Galaviz, rephrase.
Well, we'll see.
These are opening statements, not arguments. Save that for your closing.
But when they arrived on the scene, this is what they found at the scene. Clozapine, the one in the middle, I wouldn't be able to say it. Nifedipine. They found more prescription drugs, empty bottles. A closer look at clozapine, that was empty. More bottles. Baclofen, they found a lot of empty prescription bottles. You know why they were empty? They were inside Lynn. She had about 25 to 30 prescription pills in her system. And she was only supposed to have 5 or 6. And they can't see that as a suicide? When you're only supposed to take 5 or 6 and you get about 25 to 30? You know that baclofen she's not even supposed to have in her system. And she had about 10 to 15 of those pills in her system. That clozapine, she wasn't even supposed to have that in her system. And she had about 10 of those pills. That nifedipine, she was supposed to have that in her system, but not to the volume that she had. She was only supposed to have 1 or 2 in her system, and she had about 7. And you'll hear from people, clozapine kills people. Baclofen kills people. Nifedipine kills people. Reported suicides with those 3 pills. And she had a boatload of that in her system. And they're saying that no, the Visine kills her, not these 25 to 30 other pills that she had in her system, that she took, along with the alcohol. Again, more trust Lynn had in Jessy. Here's a living will. April 20th, 2018. Who does she name on the will? Jessy. And the lockbox at the bank? Jessy. Lynn died October 3rd, 2018. That's the responsibility, that connection they had, Jessy and Lynn. Do you see Anthony's name on there, or Keith, or Corrine? Jessy. You know why? Because Jessy was the one that bought her, went all her shopping, took her to the hospital. If she had a medical appointment, Jessy took her. Jessy would come to her house and change her and clean her. When Lynn would have mistakes, Jessy was the one that you would call all the time. You can have Scott Craig's going to tell you, Lynn was always calling her, like almost every single day. Jessy had to drive from Milwaukee to walk to Pewaukee to take care of Lynn. And you can say Jessy ended up quitting her job in June to take care of Lynn, because Jessy was the only person she trusted. Jennifer was living somewhere else in Milwaukee, but Jessy quit her job to take care of her. And as we all know, taking care of somebody who's in that state of mind is not easy. But Jessy would do all the shopping for her, cleaning, taking her to doctor's appointments, back and forth, back and forth. Because, again, she's in that circle. Next. I don't know if you can shorten that, but this. Yeah, can you move it a little bit? This is Lynn. See the date this license was issued? June 21st, 2018. During this whole time that this is happening, that they're claiming that this is happening. Lynn went and got her license renewed.
Not that good at that, apparently. Here we go.
And on the driver's license, you see that she weighed 150 pounds, give or take. On the autopsy, she weighed 251 pounds. From June to October. She got real sick. We're going to bring in hospital records. We'll tell you how sick she got and how many times she had to go to the hospital. Lynn was really sick and depressed. And you saw the way she was done up with the hair and nails and jewelry. She didn't look like that anymore. And she didn't want anybody to her house anymore. She didn't want any more visitors because she didn't look, in her mind, the same. She might have looked beautiful to Jessy, but Lynn didn't think she looked beautiful to other people. And you're going to hear her neighbor testify to that. Her name is Jean Tennell, that Lynn became so hidden in her home. She was depressed. Next slide, please. This is a side around, you can see it, but it basically proves that Lynn was the cyclobenzaprine. She asked, the doctor took her off of it in the beginning of January 2018. So she shouldn't even have had it in her system in October. She stopped taking it in 2018. And the next slide will be baclofen. She stopped taking it in March of 2018. She shouldn't even have had it in her system in October of 2018. Why would she take it if she stopped taking it at the beginning of the year? In such volumes, the baclofen. She's only supposed to take one a day. She had 10 to 15 in her system. Like cyclobenzaprine, why would she take it? She told it she stopped taking it. Because she wants to kill herself. She wants to die. She doesn't like life. Doesn't make sense to them, but shooting yourself with a gun doesn't make sense to me. Jumping off a building doesn't make sense to me. Stepping in front of a moving train doesn't make sense to me. Suicide doesn't make sense to us who like living. But for somebody who's depressed and and tired? Why do you want to take the life? I have no idea. But Lynn did for some reason on October 3rd, 2018. Why does she have 25 to 30 pills in her system? They don't think that's a suicide? That must have been the tetrahydrozoline. Next slide, please. They talk about eye drops, and every time Lynn went to the doctor, every time since 2017 and 18, she went to the doctor a lot of times. Pain management, Aurora, Waukesha. She always complained about her eyes. She had to take eye drops. Every single time you'll see it on her lab or after medical report, eye drops, complaint of eye drops, pain in my eyes. And they didn't understand why she was always buying Visine. She was drinking it and using it. She needed eye drops. According to the hospital records, it's not something Jessy made up. It's in the hospital records. You'll see Aurora, pain management, Waukesha, eye drops. Complaining about pain in her eyes. Next slide, please. The medical examiner said tetrahydrozoline was what killed her. And she was also using these other baclofen. She wasn't using them. She shouldn't have had baclofen in her system again. She shouldn't have had these drugs, these other drugs. They're basically saying she took these voluntarily, these other 25 to 30 pills. She took those voluntarily, along with the alcohol. But the tetrahydrozoline, no, she didn't take that voluntarily. That doesn't even make sense. You're saying she took 25 to 30 pills voluntarily? Again, 2 of them that she shouldn't have had in her system, but the Visine did it? Next slide, please. Again, these are all her prescription pills that we found that were found on the scene. That's just one of two pages that were found at the scene. Next slide. Also, it doesn't make sense. They're saying that Jessy set this up. You know, remember when officers arrived on the scene? Do you think this was a suicide? Do you think Jessy would be jumping up and down? Yes, 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 yes. It's a suicide. This is definitely a suicide. Yes. You know what she said? She goes, I don't know. I don't think so. She said, I don't know. You don't want to think the worst, but you know, she would have been saying, yeah, for sure. She did. It was a suicide, but Jessy was being honest. I don't know. And you think if she would have set it up, and according to them, the Visine is in that water bottle, why would she leave it there at the scene with her fingerprints all over it? You know, it's like shooting somebody with a gun and then leaving the gun on the scene and running away so they can find the gun and your fingerprints on it. Why in the world would she leave the bottle of Visine right there so people can find it with her fingerprints on it? If that was actually what killed her. Next slide, please. I want to touch a little bit about the finances, and they're going to mention about these checks, and you're going to hear, and I'm going to, with their witnesses, tell you that Lynn went to the bank a lot of times. When all this was going on, her checks were being used, her checks were being given to Jessy, her charge cards were being used by Lynn and Jessy. Lynn was always at the bank. She would make deposits, withdrawals. You're going to see them. Lynn would go personally to the bank and go to and do these transactions. You don't think the tellers are telling her about her account, the balances on her account? You don't think she's asking for, like, can I have a balance on my account? That's what happens at a bank. You do a withdrawal or a deposit, you get a balance. Like Lynn is now aware that Jessy's stealing this money, and they were so sure that that these checks were forged by Lynn. They were so sure at the beginning of this case. And Jesse kept telling him, I didn't forge them. Lynn gave them to me. Lynn gave me this money. That, he didn't mention, we sent the checks to the FBI to see who wrote those checks. Did he say that? Jesse said, send them to the FBI. I didn't write them. Whatever they say. You know what the FBI said? The analyst? Lynn wrote them. Jesse didn't write them. Didn't write any of those checks. Did he mention that in his opening? I don't think so.
I object to that line. That's not what the FBI report says.
We'll see.
Move on.
And you're going to see also through their documents that they gave us that Lynn applied for a loan in 2018 February for a $30,000 loan or $35,000 at BMO Harris Bank. Why would she apply for a $30,000 loan if she thought she had all this money in her bank? Why in the world would she apply for $30,000? If she had all this money in her checking account and all this money in her market account, why would she need a loan? She was denied. The bank denied her. She had all this money in her account. Why would the bank deny her? And then she tried for another loan. Her and Jesse. And I'll be honest with you, her and Jesse filed some fraudulent documents to get this other loan through Wells Fargo. Lynn and Jesse together, they applied, falsified Lynn's earnings, and she got that loan, Jesse and Lynn. But Lynn knew about it. Lynn had to go to the bank, Wells Fargo, and sign for that loan before they could get the money. Jesse and Lynn in front of the, they were together to Wells Fargo Bank to sign for that loan, March 8, 2018. Wells Fargo and Pewaukee. Again, Lynn loved Jesse. That was her daughter. She was in that circle. But if Lynn was here, she wouldn't believe that Jesse's sitting over there to start with. Had she known this was going to happen, I think she would have did something different. I don't think, never in her wildest dream would she ever think Jesse would get arrested for a suicide that Lynn committed, or being charged with money that Lynn gave to her. Jesse's innocent. You know, when he talked about that the people from probate said, we never seen this will like this. You know what the medical examiner is going to tell you? I've never seen tetrohydrozoline before either. This is my first time ever. That's when she gets up there and testifies, she goes, I've never, ever seen tetrohydrozoline. I had to research it and talk to people and read literature about it from the experts. And one of those experts is named Henry Speller, leading expert in the world on tetrohydrozoline poisoning. And you're going to hear from him. We're going to bring him in. Literature that the medical examiner read. And you're going to hear from Mr. Speller about tetrohydrozoline poisoning. She's innocent. Find her not guilty.
Thank you, Attorney Galavis. I think it'll be a great time just to have a afternoon break and give everyone an opportunity to have a little comfort break, and then we'll come back in about 15-20 minutes with the start of testimony. All rise for the jury, please.
avoid it for the future. I was just trying to figure out if there's something I should be doing differently.
No, we can ask that.
We're gonna be like a shoulder shrug or something.
Still ask them, let them know what's happening.
Yeah. Do you have a login to your fancy Adobe?
Yeah.
You do? Okay. It's free. No, you can't change it. I can't change like on the screen. No, I'm not. I can't put this on my phone.
My dirty camera. No, I have some stuff through the state, but it's an individual user, and I don't, we can look later. I have something, but I don't remember what, that's just mine. It's just an account. I'll free it.
All right, food for thought. Cause a lot of this stuff is too big.
I presume we have a witness ready to go?
Yes, ma'am.
Okay. Just,
We have 3 right now, and we just run a few minutes behind.
okay. Nice one, Rangers. Okay. Can you just check to see if we have everyone back? I don't think they went here, but make sure they're all ready to go. Was your computer air connected, like the air table or the hard?
Cables, but it was HDMI cable, right?
Oh, I was just curious.
It was just Karma.
No, I've seen it do that before. I don't,
She was
it just
wondering how it was, whether it was over air, like air broadcast, or cabled in.
cable.
Cabled in.
I
And
don't
I have
know.
the power supply in as well, because that was my first.
I don't know, maybe it's the length and it just goes quiet.
I just can't wait to watch this for real.
That's,
I think so. He's just like staring, seeing like something's gonna happen if I did.
We're just waiting for the jurors to all be ready. Hey, Scott, can you, I know sometimes people sit back there, so, you know. Like right outside the door, yeah. Yeah, awesome. Did you make headway with the flash drive?
Yes. There's just a lot of stuff that's too big. So that's why I was trying to figure out if I can open up Adobe and compress it. Or if I have, which I can't do on this computer. Or if I have to manually scan. So I'm just trying to figure out logistics. I might have to scan. I think there's one back in the cottage, which is more like the home now.
Right.
Well, not this one, but just.
Are we ready? Okay, we're all ready, so we'll be back on the record and all rise and the jury should be in shortly. in here that you were looking at? The first one?
Yes.
I see that, thank you. You're very efficient. We stand for you, so when you come in, you can sit.
Thank you.
Unless you want to stand until you're all in. Thank you, everyone. Please be seated. I see our jurors have been given notepads and pens if they choose to take notes. With that, the state may call its first witness.
Thank you, Your Honor. The state would call Deputy Rosenberger.
All right, Deputy, if you would please make your way to the witness stand, which is up a riser on my right. When you get there, please remain standing, raise your right hand, and my clerk, Teresa, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. Please have a seat. When you are seated, please state your first and last names for the record and spell each.
Christopher Rosenberger. First name is Christopher. Last name is Rozenberger.
Thank you. Go ahead. You may question the witness.
Thank you, Your Honor. Deputy Rosenberger, how are you employed?
Through the Waukesha County Sheriff's Department.
And how long have you been employed at the Waukesha County Sheriff's Department?
It'll be 13 years this January.
Okay. Have you had any previous law enforcement experience before that?
Yes.
Okay, can you get into that?
It was 6 months in the town of Dover in Kansasville. It was mostly boat patrol.
Okay, so that brief stint as well as the Sheriff's Department is your totality of your law enforcement experience, correct?
Yes.
Okay. Did you have to undergo training to become a law enforcement officer?
I did.
Can you just briefly describe for the jury some of that training?
In 2008, I completed the Law Enforcement Training Academy. After that, I was hired with my first department, Boat Patrol. In that department, being a part-time department, we didn't receive a whole lot of training until I became a sheriff in 2011. From then, we had a 2-week orientation class prior to becoming on the road. Once becoming a deputy on the road, I was on field training for a 20-week field training program. After our field training program, we continued to take additional classes for investigations, along with other specialty assignments that I'm assigned to right now.
As being a deputy, have you had training on investigating death scenes?
Yes.
Could you describe that for the jury?
Most of the death scene investigation has been originally through my police academy, where we had, I believe, an 8-hour, 12-hour class on investigating death scenes. From there, everything was hands-on with my FTOs along with my in-person experience during calls.
Obviously, you've had a little bit of an extensive law enforcement career, but if you could give an approximate number of about how many death scenes you've actually gone to as a law enforcement officer.
For death scenes, I imagine approximately 80 to 100 death scenes.
Okay. Could you describe the standard procedure for processing and assessing those death scenes?
First and foremost, our first priority is arriving on scene and making sure that the scene is secure, not that there's any other injuries to anybody. Everyone there is safe first. Along with then immediately rendering aid to anyone who is injured or is dying, or checking to make sure that there is no other additional life-saving measures that we can perform. After then, we also complete a cursory search of the house or wherever the person is located to ensure that there's nobody hiding in the residence. After that, we have our fire department pretty much coincide, come in with us as we're checking the building to ensure that the person who we have located, if they could use any further medical assistance that I can't provide, such as hooking up for heart monitors. The fire department, if it's an obvious death, usually we only bring on 1 or 2 firefighters. If we think the person can be revived, we bring in as many as we can. From there, then, if the person is deceased, we'll set up a crime scene log and we'll secure that perimeter of the residence or wherever we deem the crime scene is until we can break down that. We start a crime scene log, we take documentation of everyone who comes in and all that residence or area.
Thank you. I want to take you back about 5 years ago at this point to October 3rd, 2018. Were you on duty on that date?
Yes,
All right. Were you dispatched to a residence at North 16 West 26543 Meadowgrass Circle in the city of Pewaukee, Waukesha County, Wisconsin?
I was.
All right. On that date, can you tell me a little bit about that dispatch?
We were dispatched to a suicide. I don't recall word for word the dispatch, exactly what they told us, but they did advise that a female had located her friend deceased in a residence. Upon my arrival, along with Deputy Mitch, who I was field training, we immediately responded into the residence. From there, we were advised by the fire department just shortly prior to entering the residence that the female was deceased and there was no further life-saving measures that they could do. From there, I completed a quick search of the residence for anybody lurking inside the residence to confirm that the scene was safe, not that anyone was hiding in a closet, an attic, a garage, because we want to make sure the scene is safe. I remained with Deputy Mitch, and I believe Deputy Kajawa set up a crime scene log immediately, and we waited until further instruction.
As you were securing the residence, did you make contact with anybody other than law enforcement or EMS or anything like that?
Not inside the residence, no.
Okay. What about outside the residence?
I do not recall everyone who I made contact with outside the residence other than the deputies on scene.
Okay. Ultimately, what was your role in the investigation when you actually got on scene?
My role essentially was being a field training officer for Deputy Mitch. I essentially supervised his actions and I taught him how to investigate the scene. So I believe I did contact my supervisor. I let him know that it was in fact a death scene and that we need supervisors on scene. From there, I essentially was a shadow for my trainee to make sure that he properly investigated the incident.
All right. When you guys were investigating the incident, you were shadowing him essentially. Did you walk through the residence that you went to?
I did.
Okay. Did you and Deputy Mitch look in the garbage or fridge during that time?
I'm sure I did. I don't recall everything that I had located in the garbage or the fridge, but that is probably something I would have done.
Why is that something you would do at a death scene?
Once again, at death scenes, because we treating them all as a crime scene. That's essentially why we set up a crime scene log. We have a deputy posted at the door. We don't let people in or out. We don't know if this was a suicide or a homicide. We don't know the circumstances behind it. So I'm going to start checking areas that maybe give me some clues, such as items in the garbage, items in the refrigerator, along with I'm looking to see even if there's food in the refrigerator. Was this person living here not eating, or did they just buy McDonald's or food yesterday and they're actually eating and surviving?
At some point, did you make contact or clearly identify the decedent?
I did.
Okay. And she was clearly deceased at that point?
Yes.
Okay. Moving forward, in this investigation, did you locate a notepad on a stool in the residence?
I did. After, I believe, once the detectives had been on scene and the medical examiner was on scene, she pointed out a notepad on a stool that was along like a buffet bar area behind the sink, and there was a notepad on that stool. I was requested by the medical examiner to review and take pictures.
Did you ultimately take pictures of that notepad?
I did.
Okay. And did you review them before court today?
I did.
Or are we asking for permission to approach the witness?
We'll use the technology, right? He's going to approach you electronically, so to speak. The documents that they have, the court will see, you will see, and then presumably we'll go forward from there.
Let me know once you see what you want on your preview screen, and then I'll publish to the witness.
It's not up yet. That's your screen, or no, that's there. Okay.
You're the state rear, so are you seeing a blue screen? Because
I'm seeing a blue screen.
Yeah, one of her screens is blue, but then she also does have it up.
Drag it over to the.
Might have to, if you're using it as a dual monitor, you have to make sure it's on the correct side.
Is that what you want?
Yes. Deputy, can you see an
Hold on one
exhibit your
second, I just
screen?
want to confirm, your monitor's working?
Yes.
Thank you. Go ahead.
Deputy, can you see exhibit 1 on your screen?
Yes,
And is this one of the pictures that you had taken of the notepad on the October 3rd?
yes, that appears to be the first page of it.
And would that be a true and accurate copy of the picture that you took?
Yes,
Same questions with exhibit 2. Is this another picture of another page of that notepad?
yes,
And is that also a true and accurate copy of that page of the notepad?
it is.
Okay. Further, this is exhibit 3 now on your screen. Is this the third page of the notepad?
Yes,
And again, you took this picture,
yep,
true and accurate copy of it.
correct.
Okay. Exhibit 4 here is a lower half of one of the pages of the notepad. Is this another picture that you took on this date?
Correct,
And that's again a true and accurate copy of that.
it is.
And lastly, we have exhibit 5, which is the upper page of exhibit 1 actually here. Again, did you take this picture?
That is correct, yes.
And it's a true and accurate copy of it.
It is.
Your Honor, be moving exhibits 1 through 5 into evidence.
Exhibit 4, that's the lower half of which exhibit?
That is the lower half of page 1.
Any objection?
No.
All right, for the jury then, exhibits 1 through 5 are received.
And I'd be asking for permission to publish exhibit 5.
Any objection?
No.
All right, permission to publish granted.
Yes.
You starting with 5?
Yes.
Deputy, looking at exhibit 5, is there a date on the top of exhibit 5?
There is.
Can you just tell the jury what that date is?
9/26/2015.
Okay, so presumably this note would have been from 9/26 of 2015, correct?
That is correct.
Okay, but at least that's how you interpret it.
Yes.
All right. In looking at this notepad, so not even just exhibit 5, but all 3 pages of the notepad, in your training and experience reviewing these scenes, did you believe this notepad to be a suicide note or notepad?
I did not. Based on some of the information we received that she's had health problems, it appeared like she was essentially telling someone how to feed her cat, run her TV, feed the animals, and how to even get a hold of her in the hospital.
And to just be clear to the jury, where was this stool in the residence?
When you walked into the residence, there was an open concept, and the kitchen was in the center, kind of towards the back of the apartment, and it would be in the center where the living room was, dividing the kitchen, and it would have been on the living room side.
I just have a few more questions for you, Deputy. when, kind of going backwards, when you cleared the residence earlier on this October date, did you locate a Jeep or a vehicle in the residence or in the garage?
I did.
Okay, what was that vehicle?
I recall opening up the door to the garage. I saw a Jeep Wrangler, and I even recall making a comment to my partner because she had the same vehicle, saying, hey, she likes Jeeps too. That's the reason I remember it being in there.
Thank you. Just one last question. Deputy, did you have any other further duties in this investigation?
Essentially from just supervising my trainee, no. I was asked to take pictures, and after completing pictures, I remained with my trainee.
Thank you, Deputy. I don't have any other questions.
Thank you. Cross, and do you need any of the exhibits published while you're questioning?
Yes, we might. And we're gonna have another exhibit, so we need access on our computer.
Go ahead.
So, good afternoon, Mr. Rosenberger. At the scene, you made observations then,
I did, yes.
and you wrote a report,
Correct.
and your report is about a half a page.
That is correct.
As part of your training in law enforcement, you're told to record anything that's significant,
Correct.
and then put it in a report form,
That is correct.
and you did that.
I did. I documented my job on the scene.
Right, which was to, you said today, to look at everything.
Correct.
And there's nothing in here about looking inside the refrigerator.
That is correct.
What, you said you looked in the refrigerator.
To my recollection, yes.
What was in her refrigerator? Tell me the items that were in her refrigerator.
From 5 years ago, I do not recall what was in her refrigerator.
One of the reasons why you would put it in a report, right?
I would, unless I found something that stands out to me, I would not document that in my report.
But one of the benefits of preparing a report is to be able to, months or years later, to be able to go back and look at what you did at a previous date and refresh your own recollection.
Correct.
You read your report to refresh your recollection, didn't you?
I did.
And you met with the district attorney's office to prepare?
That is correct.
And is that why today you came in on exhibit, which exhibit was this one? Exhibit 1, and told us today that the date on the note was September 26, 2015, because they pointed out to you that in your report you wrote 2018, right?
That is correct, and I'd like to answer that
And,
further.
no, I just asked you.
Okay.
Follow-up.
And so when you were there in October of 2016 or 2018, it was at your testimony that the medical examiner is the person, the deputy medical examiner is the person who told you to take these photographs?
That is correct.
You wouldn't have done that otherwise.
At that point, I was unsure what the other detectives had fully taken pictures of.
Well, you said you were in a training mode that night.
That's correct.
You were in charge of, you were training another person.
Correct.
So you were taking charge of things and telling him what he should and shouldn't do, right?
My trainee, not the detectives on scene.
Your trainee, Mr. Mitch, did you
Yep.
say?
Yep.
When you took photos, these photos that you showed today, did you take any photos of the refrigerator?
I did not.
Did you take any photos of the garbage cans?
I did not.
You said you looked in the garbage cans.
I believe I did, yes.
How many garbage cans are in that house?
At this time, I do not recall how many garbage cans were in the house.
Well, what was in the garbage cans?
I do not recall.
Okay, so you looked at them, but you have no idea of what was in them.
That is correct, yes.
You don't remember seeing alcohol bottles in the garbage cans.
I do not recall that right now.
You don't remember seeing Visine bottles in the garbage can.
No.
How many bathrooms were in this unit?
To my recollection, I believe there were 2 bathrooms.
Okay. Did you take any pictures in the bathrooms?
I was not assigned with taking overall pictures of the residents.
Was the medical examiner assigning people to take certain pictures?
Negative, no.
Okay, so somebody else was taking pictures, but if the medical examiner wanted some, you took them?
That's correct. Detective Wilberg was had taken the initial pictures, and then that notepad was located additionally by our ME while we were securing the scene or investigating, and she asked me to take additional photographs of it, which is not very uncommon.
Well, when the medical examiner provided us with copies of scene photos, who took the medical examiner scene photos?
I'm sorry, can you ask that again?
Do you know who took photographs at the scene for the medical examiner? Was there somebody doing that?
Detective Wilberg took pictures on our behalf, and I believe the medical examiner took her own photographs.
Was it her, she took them herself?
I believe so, yes.
You saw her taking photos?
To my recollection, I believe she took the photographs.
Now, did you collect any of these pads as evidence?
I did not.
Did anybody at the scene collect these notes?
Not to my recollection, no.
And the note that you talked about on Exhibit 1 is a note from 2015, is that right?
Correct, that's what was written on the top of it.
And it looks like, can we show this exhibit? Number 1?
Yeah.
There we go. Can you make it a little smaller? Sure. We're going to bring up what's already been admitted as Exhibit 1. Can you see that all right on your
No,
screen?
he doesn't have it yet.
Is that
Ah.
what you want?
Yes, I'd like to
Okay.
display it. It's already been admitted into
Am I publishing it to
evidence.
everyone or just to?
To everybody.
The exhibit has been received and published. It may be presented in the courtroom.
Thank you. So it looks halfway down like Lynn wrote 1-262-928-1000 is scheduling desk at hospital and will transfer you to whatever room I'm in. Do you see that?
Yes.
So as you read this, and a lot of this is about here's how to take care of my cats, leave the TVs on so the cats can have the TVs, don't touch the antenna. Instructions for Jenny, it looks like, right?
Yes.
And that's Jenny Flower.
That's what it says at the top.
And that's Jesse's mom, is that right?
I do not know that.
Okay. And she talks about her living will on here. Is that right?
Can you zoom in a little bit?
And this is somebody, that's okay. Somebody who's going to the hospital back in 2015, right?
Correct.
Did you take the picture at the scene of the checkbook register with notes on it?
I don't believe so.
Did you take a picture of the Lynn's driver's license?
No.
When you said the first photograph I took was of the photo identification card at 1907 hours, what photo identification card are you referring to?
For us, at the beginning, before taking pictures, we actually take a photo card that has the date, the address we're at, what time, our incident report number, and location, including the person who's taking the picture. So when our detectives get these pictures, they can identify what case this is from.
Got it.
Are we done with exhibit 1?
Yes, done with that.
Thank you.
Did you take make a list of of drugs that were found at the scene?
I personally did not.
That's all, thank you.
Thank you. Any redirect?
Just briefly here, Deputy Rosenberger, there was some discussion about 2018 versus 2015. Can you just tell the jury what happened with that discrepancy?
At the time, we used typists, so we either call in via a phone, like a voicemail system, or on a recorder. Once we were completed with our reports, that we would upload them, and typists actually have to listen and type as you're talking into the recorder. And I believe that being that discrepancy, they may have heard 2018 instead of 2015.
And the jury was able to see in the exhibit 1 here, and I believe actually in exhibit 5, that it's clearly a note from 2015, correct?
Correct.
Also, there are some questions about how in your report, or lack of notes in your report, is that because nothing stood out to you on scene?
At that time, no. And furthermore, being a field training officer, I'm more hands off and I'm letting them do the investigation, and I'm essentially there guiding them. So when Deputy Mitch completed his report, I made sure that he described the details and the residents to our knowledge.
Thank you, Deputy. I don't have anything else.
All right, thank you, Deputy. You may step down.
No recross, Your Honor?
No.
State's next witness is Kelsey Michelson.
All right, please have her come in. Good afternoon, Ms. Michelson. If you would please make your way to the witness stand. It's all the way to the front of the courtroom to my right. It is up a riser. When you get there, please remain standing, raise your right hand, and my clerk, Teresa, who's on the left, will swear you in. You're over here.
Oh, sorry. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Please have a seat. The first thing I will ask you to do is to state your first and last names for the record and spell each.
Kelsey Michelson, KelseyMichalsen.
Thank you. Go ahead. Attorney Crawford, is this still your witness?
Yes.
Go ahead.
Your Honor, I apologize. Just briefly, I'd be asking that Deputy Rosenberger be released from the subpoena.
Is he under any defense subpoena? Attorney Kukler?
No, he's not.
All right, he may be released.
Thank you. All right, Ms. Michelson, can you just tell me what you do right now for a job?
I currently work as a tech in the ER at Frater Hospital.
Okay. Additionally, do you have any experience in law enforcement?
Yes, I've been a law enforcement officer since May of 2018.
Okay. Are you still employed in a law enforcement capacity at all?
Yes, I work part-time at the Village of Pewaukee Police Department.
In what sense?
I'm a boat patrol officer there.
All right. So I believe you said May of 2018 is your extent of law enforcement experience?
Correct.
All right. Can you just tell the jury the training that you received to become a law enforcement officer?
I have a 2-year associate's degree that I received in 2018 as well. Additionally, I had 720 hours of the Law Enforcement Academy, which I graduated in May of 2018. I had additional training in my job as a law enforcement officer as well.
Were you employed with the Waukesha County Sheriff's Department in October of 2018?
I was.
All right, so I think you said you had finished up your training and the academy and all that in May, so you'd been on the job for about 5 months or so, is that fair?
Correct, and I was off field training at that point as well.
Okay. On October 3rd, 2018, were you dispatched to a residence in the Village of Pewaukee for a death investigation?
I was. It was an assist EMS.
Okay. What was your role in that investigation?
I received a witness statement from Jessy Kurczewski on that case.
Okay. Do you see that individual who you identified as Jessy Kurczewski in court here today?
I wouldn't be able to identify
Okay.
her.
It's been 5 years, obviously, so.
Hold on, was that a yes?
I would say no.
Well, you shook your head yes, though, when you were acknowledging his
apologize.
Do you agree that you shook your head yes when he asked you if you would not be able to identify her?
Yes.
Okay, thank you. Go ahead. Sorry, it's my job to make sure if someone nods their head, shrugs their shoulders, or says, that I make sure the record's clear what you meant. So thank you.
Thank you, Ms. Michelson. So you had stated that your role on scene here was to get a statement from this Jessy Kurczewski individual, correct?
Correct.
All right. So in part of getting her statement, did she provide a written statement to you, or was it verbal?
It was both.
Okay. Can you just tell me what you recall about that statement that she gave you?
Yeah, so when we get a statement from witnesses on the scene of a death investigation, we go over the last 24 hours that they had with the victim. From what I remember with Jessy's statement, she stated that she last saw her around 10 a.m. that day when she left to go run some errands. From what I knew, Jessy was the caretaker of the individual that we were on scene with. She saw her that morning, tried to feed her some breakfast. She wasn't willing to eat. She tried to change her. She usually sits on a Chuck's pad to collect any urine that might go on. She wanted to be left alone. Sounded like the individual that had died that day was kind of becoming more increasingly sick as the past couple of days went on, or over the past year even. And Jessy really mentioned that she just felt that the victim, or not the victim, the person who had died was starting to decline pretty fast. She wouldn't take her meds the night before. And Jessy also noticed that some of the pills had gone missing. I didn't clarify if she counted each pill every time she gave him, but Jessy was the person who would usually give the person who died her pills.
So you said you took both an oral statement as well as a written statement, correct?
Correct.
So a written statement, was that part of this case? Did you turn that into property or anything like that?
Oh, I'm sorry, can you repeat?
So, yeah, it was probably a bad question. When you took her written statement, Jessy Kurczewski's written statement, did you submit that to this case for this investigation?
I did.
Okay. And did you have a chance to review that written statement before court today?
I did.
And was that written statement a true and accurate copy of the written statement that you took from Ms. Kurczewski on October 3rd, 2018?
It was.
Okay. I believe that is actually marked Exhibit 6. So.
Is that the right one?
Yes. Do you see anything on your screen?
My screen's black.
Okay.
No, I see it.
All right. Exhibit 6, is that the written statement that Jessy Kurczewski gave to you?
It is.
More distinctly, that's the first page, correct?
Yes.
Ultimately, there is, I believe, 3 pages to this written statement of hers. Is that a yes?
Yeah, I believe that's right.
Okay. Your Honor, be moving Exhibit 6 into evidence and ask for permission to publish.
Any objection? No. Exhibit 6 is received. Permission to publish is granted.
So, Ms. Michelson, as part of this written statement, I believe you had talked about earlier, you believe that she left the residence around 10 o'clock. Is that correct?
I believe so, yeah.
And does that add up to the written statement that Ms. Kurczewski had provided?
Yes.
Okay. In the written statement, is there talk about whether or not, when she arrived back at the residence, what Ms. Kurczewski did?
I remember it saying that she kept talking to the deceased individual on scene and felt that there was no pulse, and then she called 911.
Additionally, as part of this statement, is there a discussion about in-home healthcare?
Yeah, there was supposed to be in-home healthcare. I don't remember the exact date. It should be in the statement when they were supposed to come. Jesse had stated that the deceased individual had pushed it off till later that week.
If I could just direct your attention to the bottom of page, or Exhibit 6, page 1, the third line from the bottom. I believe that discusses it. Can you just read out that sentence to the jury?
Yeah. She was to have home health care come Monday this week, and she pushed them back to Friday.
Thank you. Additionally, as part of this written statement, did you ask Ms. Kurczewski if she thought the decedent, who is identified as Lynn Hernan, was suicidal or wanted to die?
I did.
And would that be on page 3 of Exhibit 6?
It is.
Can you just read her answer in whole to that question, please?
Yes. So Jesse's answer was yes and no. I know she loves her cats and was always worried about them, but she was tired of being sick and tired of not being able to get around like she used to.
I know you said that you wouldn't be able to identify Ms. Kurczewski, but from what you remember about that interaction with her, do you recall her demeanor during that time?
Yeah, I don't recall her being like extremely upset or anything. Isn't super abnormal in a death investigation either. It's not out of the ordinary, I should say, from what I've seen.
I just have a few more questions, Ms. Michelson. Do you recall what Ms. Kurczewski was wearing at the time?
I don't recall.
Okay. And additionally, I'm going to take us back to actually page 1 of Exhibit 6. I'm going to have you, can you just read into the record the sentence after I had errands to run, I left around 10-ish? Right around the middle of the page.
Yep. I returned back shortly before 5 p.m. and just thought she was asleep. She usually is when I get here. I kept talking to her and checked her pulse and called 911.
And additionally, well, you don't remember what Ms. Kurczewski was wearing at the time. At the top right, I believe it talks about what her employer would have been, correct?
Correct.
And filled in there as it says that she's not working at the time of taking care of the decedent.
Correct.
Thank you, Ms. Michelson. I don't have anything else.
Any cross?
Good afternoon, Ms. Michelson. So
Do you need
you
this?
went to the scene.
I'm sorry
at-
for the interruption. Do you need the exhibit up?
I'm not at the moment, no.
Okay, thank you. Again, sorry for the interruption.
You got to the scene, you made observations. Is that right?
Correct.
Did you say you were done with your field training at this point?
I was.
When did you finish your field training?
I believe it was in July of 2018.
All right. And when you arrived at the scene, were the other officers already there?
I believe I arrived at the same time as Deputy Kralowitz.
And what about Deputy Mitch?
I believe he arrived after us.
Okay. So you're one of the first on the scene.
Correct.
Did you review your report before testifying here today?
I did.
Met with the district attorney to prepare?
I did.
And now you're working at ER at Fredert?
Correct.
Now People don't all react the same way when you report to a death scene. Isn't that true?
Correct.
There's no one size fits all when it comes to that.
Most definitely.
In fact, when police come to talk to somebody, sometimes people are really trying to hold it together to answer questions the best they can. Is that your experience?
That's true.
People try to cooperate with you,
Yep.
answer things the best they can.
Mm-hmm.
Yes?
Yes, sorry.
Even when they're in a state of distress or a state of shock, they still try to cooperate with you.
Correct.
You've seen that.
Yes.
Now, when you asked, it looked when you got there and you made observations, it looked to you like a suicide, didn't it?
I don't believe I ever went in the house.
Oh, you never did.
I don't think so. I can't recall.
Were you told that it looked like a suicide?
I don't remember. I would assume so based on some of my questioning.
Okay. So somehow you got an impression that this was probably a suicide, and you were to ask Jessy questions about that.
My overall impression was it was a person who was very ill that had passed away. That's what I remember, at least.
And you knew that the person was very ill because one of the things that you learned is that Lynn, the deceased, had just been released from the hospital on September 28th, right?
My impression was made based on all of her medications that she had and Jesse's statement that she was released from the hospital. And
you learned that the patient was supposed to have a healthcare visit on Monday, 2 days before she died, right?
yes,
And the patient pushed back the appointment.
that's what Jesse said.
And that appointment had been pushed back to Friday. It's what you learned.
Correct.
And you talked about Jessy telling you that there had been some odd behavior by Lynn during the week,
Correct.
in those few days that she had been out of the hospital,
Yes.
and that she was quite sick.
Yes.
And Jessy told you that, for one thing, Lynn was throwing out bills
Yes.
and saying things like, the hospital won't get my money.
Yep, that was an understatement.
And Jessy told you that Lynn's pills were off.
Yes.
And you didn't look to see how many pills Lynn was taking, right?
No, that was Deputy Mix's job in that case, I believe.
And she told, and you learned through Jessy, that Lynn didn't want to go into a nursing home.
Correct.
And she was constantly worried about having to leave her home because of being sick.
That's what Jesse said.
And worried that she was going to have to go in some kind of a facility.
Correct.
And you learned that Lynn was tired of being sick and tired of not being able to get around like she used to.
That's what Jesse had said.
And that's what you're here to testify to today, right?
Yeah, what Jesse had said to me, yes.
All the things that you testified to for the state were things you learned from Jessy too,
Correct.
right?
Yeah.
Okay. And you asked Jessy, do you think Lynn was suicidal? That's one of the things you asked her.
Yep.
And she said yes and no.
Yes.
She didn't say, absolutely, this woman was suicidal. This is a suicide. She didn't do that.
She did not do that, no.
Did you see that Jessy was named as a power of attorney for Lynn? Were you privy to those documents?
I didn't see the specific documents. I know that Jesse did tell me she was a power of attorney, or was listed as one.
As part of your role, did you ever go and check the garbage cans or anything in the house?
I don't think I ever went in the house.
Did you maintain the log outside of who was coming in and out?
I don't remember if I did or not.
Isn't it true that when you saw Jessy outside before you started to talk to her, that she was sitting outside crying?
I don't remember that.
Weren't you consoling her?
I don't remember that either.
So your memory's really pretty vague from this day?
I would say so, yes. This case didn't stand out particularly high to me, I guess, and stuff. It was somewhat of a normal work day.
Thank you.
Any redirect?
I believe there are some questions about your knowledge of what happened inside the residence. I just want to confirm, from your report or what you recall, do you have any knowledge of any pills inside the residence?
I do know there was pills inside, yes.
Okay. And did you have any specific knowledge of how many pills or what kind of pills were inside the residence?
I specifically remember that Deputy Mix spent a lot of...
Object beyond the scope of my cross. As to specific pills.
Overrule.
You can continue.
You may answer.
Okay. Can you ask the question again, please?
Yeah. So you're talking about how you had knowledge roughly that there was pills inside the residence. Did you know what kind of pills there were? How many pills there were? Those types of things?
Object is calls for hearsay.
I don't know.
Sustained as to the form of the question.
I'll move on. I don't think it's really that relevant. Did Jessy Kurczewski tell you in this written statement or oral statement that Lynn had been trying to kill herself with eye drops?
No.
Okay. So there was no discussion about eye drops, correct?
Correct.
Object to beyond the scope of my cross. It's going into new territory.
The answer may stand, but please move on.
I don't have anything else. Thank you.
Any redirect, or recross based
No.
on that? All right, thank you. You may step down.
Thank you.
Your Honor, the same situation with Miss Michelson. I'd be asking that she be released from her subpoena.
Any objection?
No.
All right, that request is granted.
Thank you. The state would next call Tabitha Kooks.
All right. Good afternoon, Ms. Kooks. If you would please make your way to the witness stand, which is all the way to the front of the courtroom. It is up a riser. When you get there, please remain standing, raise your right hand, and my clerk, Teresa, who will be across from you to the left, will swear you in. She's to the left.
Do you solemnly swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Thank you. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and spell each.
Sure. Tabitha Kookas, T-A-B-I-T-H-A. Kookas, K as in King, U as in Union, K as in King, E as in Edward, S as in Sam.
Thank you for correcting how we said your name. My apologies. Go ahead, your
Not at all.
witness.
Thank you. Ms. Kookas, were you previously employed as a deputy medical examiner here in Waukesha County?
That's correct.
And how long did you work in that capacity?
From February 2015 until November or December of 2021, I believe. It was almost 7 years.
As a deputy medical examiner, can you just explain to the jury what goes along with that?
Absolutely. So, deputy medical examiner in the in the county of Waukesha, essentially we have to be the eyes and ears for the medical examiner. Due to the volume of deaths in the county, it's impossible for the pathologist to individually attend each death. So it was our job to triage those cases on what could be released under natural circumstances and what needed further investigation. These cases might come in as phone calls from a hospital or a nursing facility. It would be a death attended by medical personnel, and we could answer questions from the nurses and doctors. Or in this case, it might be something that happened outside of a medical facility, unattended by any personnel, and would require response by our department to the scene. These were what we called scene deaths. We would go to the scene, we would interview anyone that was there. This included law enforcement, paramedics, witnesses, family, friends, those who found the decedent. We would collect evidence, we would document circumstances surrounding the death, we would do a body examination, and we would legally pronounce the death. Then we would determine whether or not this particular death required additional investigation by the pathologist, and if so, we would bring that decedent with us back to the office. We remained custody of the decedent, and then they would often have either an external exam or an autopsy with toxicology testing at the discretion of the pathologist.
A lot going on there, it's fair to say. Did you have to undergo any training or education to become a deputy medical examiner?
Yeah, it varies from county to county on what they require. For me personally, I have an undergraduate degree in anthropology and archaeology. I have my master's degree in biological anthropology, which had additional training in death investigation and genocide. And then I also completed a training course at St. Louis University in medical legal death investigation. Additionally, after being hired at Waukesha County, we underwent yearly ongoing education training, conferences, and of course there's on-the-job training that you receive.
Okay. As part of being a deputy medical examiner, I think you might have touched on it, but I want to really emphasize this here. You're involved in death scene investigations, correct?
Correct.
Okay. So in those investigations and in death scenes over the time of your about 6 or so years that you were a deputy medical examiner, about how many death scenes did you process?
Through my entire career, I'd say over 600 were scenes, over 1,300 death cases overall.
As part of those death scenes, and I think you might have touched on it, but again, I want to highlight these things. What sorts of objects or things are you looking for at these scenes?
Sure. So obviously we're looking at the decedent themselves. We're looking at body position. We're looking at things like rigor, which is how stiff the body is, and we're looking at things like lividity, which is the blood pooling after death. That's just an effect of gravity, but we can use these things to determine whether or not the person is in the position that they died in or could have been moved afterwards. We're looking for evidence of medical history, the medications that are on scene, any paperwork. We're also looking at circumstantial evidence that's both surrounding the decedent themselves, but also in their home. Everybody lives differently, but we see a lot of patterns that present over time. So there are indicators of whether or not someone's an alcoholic, whether or not they take care of themselves. Are they home a lot? Do they hardly leave their home? We're using all of these things, I guess, to understand their life and what they may have been going through at the time of their death.
On October 3rd, 2018, were you dispatched to a residence in Waukesha County for a death scene?
Correct.
Was that death scene involving an individual, Lynn Herman?
Yes.
Okay. What did you first observe when you entered the residence?
Immediately upon entering the residence, you walk into the living room, which was open to the dining and kitchen area. So it was immediately obvious that the decedent was there in a recliner.
Did you ultimately pronounce her deceased?
Correct.
How long does that process take?
I guess it varies. There's a few steps involved that we follow per protocol for determining if someone's deceased. We check lividity, we check their body temperature, we check rigor, we check their pupils to see if there's any dilation to touch or light. We look to see if there's any reflex whatsoever. I would estimate the actual body exam itself can be performed in 5 to 10 minutes. But typically, by the time you walk in, you make contact with the police department, you do kind of a sweep of the area to get your bearings, take a few photographs. You're usually looking at 30 minutes or so after you've arrived to where you actually make that time pronouncement.
Okay. In this case, do you recall the time that you pronounced her deceased?
I do not.
Okay. If I was to tell you around, give or take, let's say 6:35 p.m., would that sound about correct?
Sure.
Okay. As part of your investigation, do you take photos of the residents?
We do.
Or where they actually were deceased?
Both. So we want to take photos of the decedent themselves and show their body position. We want to take a close-up photo of their face for identification purposes. We take photos of any objects that are surrounding the area of the decedent, but it's also common to take overall photos of the home. It's essentially a documentation process that allows the doctor to go through our photos as though they were there themselves and get kind of a vibe of what's going on. And then anything that stands out to us, we would also document.
Did you review those photos that you took of this incident before court today?
I did.
Okay. I'm gonna have those eventually put on your screen here, starting with Exhibit 7.
Okay.
How many photos are we talking about?
There's 14 originally.
All right, and this will be starting with
Exhibit 7.
number 7?
Yep. Yes.
Are you going to go through them all with her quickly to identify them before we publish, or one by one?
I'm going to go through them all quickly.
All right. Thank you. And it's on her screen and obviously not in front of the jury yet.
Okay. Do you see Exhibit 7 on your screen?
I do.
Is this a picture that you took of the decedent, Lynn Hernan?
It is.
Okay. And is that a true and accurate copy of that photo?
Mm-hmm.
Is that a yes?
Yes.
Okay, thank you. Exhibit 8, is that also a picture that you took of the residence?
Yes.
Is that a true and accurate copy of the photo that you took?
Yes.
Exhibit 9, is that a photo you took of the residence?
Yes.
Again, is that a true and accurate copy of the photo?
It is.
Exhibit 10, same questions.
Yes. And yes.
Thank you. I'll just make, I guess I'll ask you at the end, or with all of these, a blanket statement. Are all of these photos that you had taken on this date? Once we get there, I'll ask you that at the end, okay? So let's move on to Exhibit 11. Okay, we can move to 12. Exhibit 12. Exhibit 13. Exhibit 14. Exhibit 15. Exhibit 16. Exhibit 17. Exhibit 18. Exhibit 19. Exhibit 20, and then there's actually a jump in exhibits because we had a minor break. So I'm going to actually show you Exhibit 130 and 131 as well. So again, all blanket questions for these. These are all pictures that you took, correct?
Yes.
And are those true and accurate copies of those pictures?
Yes.
Or move Exhibits 7 through 20 into evidence, as well as Exhibits 130 and 131 into evidence.
Any objection?
No.
I'd also be asking for permission to publish all of these exhibits.
Exhibits 7 through 20 and 130 and 131 are all received. Permission to publish is granted.
So here's Exhibit 7 on the screen. Again, this is just a picture of the deceased, Lynn Hernan, correct?
Correct.
Exhibit 8, what are we looking at here?
We're looking at the front door there and the rest of the room.
What are you looking for in these types of pictures?
I wouldn't say there's always something specific we're looking for. We're kind of trying to just give a profile of what the room looked like. So for instance, putting those two photos together, I can showcase that she was in a position in which she may have been watching television. That might have been an area she spent a lot of time in, and it makes sense that her recliner is pointed towards the television. She also has view of the front door, but I wouldn't say this particular photo is trying to say anything specifically so much as just to showcase the room.
Thank you. Exhibit 9. Is that what Exhibit 9 is as well? Just trying to showcase the whole residence here?
Correct.
Okay. Exhibit 10, what are we looking at in this exhibit?
This is a close-up of an area near her. I'm showcasing that she has multiple medication bottles that are within arm's reach. She has, she clearly smokes. She has an inhaler. She has got items such as pre-moistened towelettes near her. So that can be indicative that someone's spending a lot of time in that particular chair or that particular part of their house because they have daily living things near them. I'm also showing that she has multiple medications that are kind of scattered on her carpet. There's some disorganization going on. There's a spoon out of place. I'm kind of just showcasing how she lived.
Okay, thank you. Exhibit 11 here, what are we looking at?
This is a close-up of the medication bottles that were directly to her left. I'm trying to showcase the names that are on the medications as well as that her name is on each medication.
What are we looking at here in Exhibit 12?
Same thing, this is to the right of the decedent. So I'm showing that there's additional medications that are present, some without their caps on. Water bottles, just kind of showing what is within arm's reach or what's near her.
Is this a close-up of that same table?
It is.
And just for the record, I'm referencing Exhibit 13. In Exhibit 14, what are we looking at here?
This is a close-up of her face and as well as the unknown residue that's on her chest.
You said earlier that you did this for about 6 years or so. Is anything strike you as out of the ordinary with this picture?
The residue on her chest, absolutely.
Why?
That's not something I had seen previously. It's not, regardless of what the residue is, whether it's an illicit substance or a prescription medication, that's not an appropriate way to take any medication. There's a lot of large pieces as well as crushed residue. It's difficult to tell from this picture, but I believe the next slide shows a close-up of her mouth in which you can see there's a piece still in the corner of her mouth. So this to me is indicative that at the very least she's taking her medications inappropriately. Even if it's something that you're prescribed, taking a medication inappropriately can cause an intoxication. So anytime we see a unknown residue or unknown substance or improper use of anything, that's a red flag for intoxication and unnatural death.
Exhibit 15, similar question.
Same thing, just a different angle. This picture shows a little bit better that there is part of a tablet that's still in her mouth, and then just a different angle or different showcase of the residue. This photo does a better job of highlighting that it's multicolored, so I would imagine that to mean multiple different tablets. Most tablets don't come with more than one color, so we have different tablets that are likely crushed here.
You were talking about a drug intoxication or those types of terms. Is this layout and the way those drugs are situated on an individual typical of a medication suicide?
No, I would say that's atypical. Usually when people overdose on their medications, they still swallow them. I have had cases where people were snorting particular medications to get that effect faster. But I would imagine most of us would have a very difficult time trying to snort off of our own chest. So that doesn't really explain that for me. There's also some very large pieces there that would be difficult to snort. So, and with the piece in her mouth, then it looks more like she's eating them. And I don't have an explanation for why, if she was eating them, so much would be on her chest.
In Exhibit 16 here, what are we looking at?
This is a pile of documents that was in the living room directly to the right of the decedent. We do typically take photographs of anything that looks to be important. It's not atypical for people who commit suicide to leave important information out, passcodes, passwords for their bank statements, things like that. So she had a lot of information, a lot of paperwork that was in a pile in her living room. This particular piece of paper is her power of living will. So I was taking a photograph of that for its importance and also in an attempt to locate next of kin.
And Exhibit 17, what are we looking at here?
It looks like I pulled that piece of paper out and then took a full photograph. I mean, originally, the first photograph is finding it in situ, and then this photograph is taking an entire photo of the piece of paper.
What are we looking at in Exhibit 18?
It's typical for us to take photographs of driver's license for identification purposes, make sure we have the name spelled correctly, the address.
Perfect. So you were the one that would have been taking that picture?
Yes.
Okay. Exhibit 19, what is this photo?
This is in her bedroom. This is a locked safe that was found in that position. It was open upon my arrival, and there appears to be another copy of the will inside.
Do you recall if there was anything else notable in her bedroom?
Not that I recall.
Okay. Is that power of living will essentially the same document that you would have located next to her in the living room?
It appeared to be the same, yes.
In Exhibit 20, what are we looking at here?
We typically document valuables, so I'm just taking a photograph of the jewelry that she's wearing.
Why do you do that?
For evidence purposes, that way if, say, she goes to the funeral home and family comes forward and says they're missing a giant sapphire ring, I can go back to my photographs and show that she wasn't wearing that particular piece of jewelry upon my taking custody of her. So it's basically just a trail of evidence for anything that might be deemed valuable.
So when the ME's office takes her body, her jewelry stays with her, correct?
Yes, anything that's on her is going to come with her to the medical examiner's office.
Okay, thank you. 130, I believe, is that just a kind of opposite of
Yep,
spectrum
just
of the
another
previous photo?
view showcasing the various pills and capsules that are on the floor. Saltine crackers can be indicative that someone's not feeling well, just showcasing what's near her.
Okay. And lastly, 131. What are we looking at in this picture?
I presume that is where she crushed whatever was on her chest. It's a plate with medication like that's the cap to a medication bottle, and this appears to be an unknown powdery substance left behind on a plate.
Okay. When you went throughout the residence, did you go into the garage? Do you recall?
I don't recall going into the garage.
Okay. There's obviously the pill bottles from one of the earlier exhibits.
Mm-hmm.
Did you take inventory of the medication that was found in the pill bottles?
Once I took them back to the medical examiner's office, I did.
Why is that helpful?
That's our protocol. It can show things like whether or not they're taking their medication appropriately. You know, if not as many pills are in the bottle as should be. If there's too many in the bottle, then we're not taking our prescription medication. For her in particular, I recall some of those bottles being rather outdated. So she had a collection of medications that would not have correlated to the month of her death. So that could be indicative that she's saving her medications. It could be indicative that she didn't take them appropriately. It could be indicative that she's been living in a state where she's been primarily on that recliner and in that living room ill for some time.
And again, is this inventory of that medication, is that important to your office in determining the cause and manner of death?
That could be viewed either way. On the one hand, no, because all that really matters is what the toxicology shows. All that really matters is what's in the decedent's bloodstream at the time of death, not necessarily what's there. And on the other hand, sometimes we take that medication back and we find another doctor's name that we can use to track down additional medical history, or it helps us, answer questions. The family might come back and ask us, is she taking her medications? Should we have made her take her medications? And the counts might help us answer those questions. So I think it's important for the overall investigation, but not necessarily important for cause and manner of death.
While you were the one that inventoried the medication, actually, can you say where those missing pills would have been potentially?
What do you, I don't understand.
So if she doesn't have the correct amount of prescription drug in the bottle, would you be able to say where those pills are?
No, she could have, no.
And I kind of want to go back a little bit to Exhibit 131. So you're under the assumption that this is crushed medication, correct?
It appears to be some sort of crushed unknown substance.
Do you know how that medication or substance got crushed?
Object speculation.
Overruled.
You can answer that.
I could theorize, but no, I don't know for certain. There was an explanation that was given to me by...
Object to hearsay. It's going to call for hearsay.
The original question was answered, so I'll sustain the objection as being narrative, and you may ask your next question.
Thank you. As part of taking inventory, though, of medications, so we're going to kind of jump back to that. Does the medical examiner's office have that in their file?
Yes.
Okay. And did you review that property or inventory before court today?
Yes.
Okay.
Are you done with the photos?
Yes. And I
Thank
believe
you.
those are marked as exhibits 21 and 22.
All right, you can show them to the witness first.
I'm showing you exhibit 21. Can you just describe that?
It's not up on our screen just
sorry.
yet. There's a delay sometimes. It's up now.
Okay. Can you describe exhibit 21?
It's an inventory of the medications that I took custody of from the scene.
And is that a true and accurate copy of that?
Yes.
Okay. I believe there's actually 2 pages of that. I just want to confirm that.
Yes.
That's a different exhibit.
This is the second page.
It is? Okay.
All right. Now
Sorry about
moving
that.
to exhibit 22. Can you describe what that is?
It's an inventory of medication from the scene.
Okay.
It's an inventory of things that were not found within a medication bottle that I would have used an outside source to identify that particular medication to the best of my ability.
And And again, that's a true and accurate copy of what would be in the medical examiner's file.
Yes.
Looking at Exhibit 22, I don't see a drug or talk of any eye drops or Visine. Would you have noted that on this exhibit?
No.
Okay. Speaking of that, though, you were making, notes of things on the scene. You were taking photos of items that were on the scene. Do you recall any eye drops or Visine?
Not that I recall.
Okay. And just for the record, Your Honor, move exhibits 21 and 22 into evidence.
Any objection?
No.
Exhibits 21 and 22 are received.
Moving forward in this investigation, did you have any contact with a Jessy Kurczewski?
Via phone.
Okay, when did that take place?
The night of the death, after I returned back to the medical examiner's office, I did reach out to her.
So you didn't make any contact with Ms. Kurczewski on scene?
She was no longer present.
Did that strike you as odd?
Yes.
Object.
Sustained. I'll strike the answer, lack of foundation.
So Ms. Kurczewski didn't remain on scene, correct?
Correct.
And in your 6 years of being a deputy medical examiner, is it common for individuals who are related or friends or family to stay on scene of these investigations?
Yes, they usually stay on scene.
Okay. In this case, again, Ms. Kurczewski didn't stay on scene. Did that strike you as odd?
Yes.
So you did have contact, though, with her over the phone later that night, correct?
Correct.
What did you talk about?
We talked about Ms. Hernan's medical history, why Ms. Kurczewski was involved in visiting her often, her behavior, just kind of background information about the decedent themselves.
All right. Moving forward, did you have any further communication with Ms. Kurczewski?
I believe she called the office a few times after that.
Okay, what was she calling the office about?
She wanted the cause and manner of death.
All right. Do you recall when that was?
I do not.
Your Honor, may I approach the witness to refresh her recollection with her report? I don't have a physical exhibit or anything like that.
Sure. Please show the document to the defense first.
And just to clarify the record, it's actually the case call log, not her investigative report.
All right, please make sure you mark it for identification purposes.
Okay. Ms. Kukas, can you read out to the jury?
Hold on, you need to establish she knows what that is.
Okay, apologize. Do you recall looking at this case call log before court today?
I do.
Is that a true and accurate copy of that case call log?
Yes.
And again, I'll get that marked as an exhibit later, but you would have inputted that information in there, correct?
Yes.
Okay. I want you to read off to the jury in terms of the call log, the second call log down from the top.
I'll object to her reading from this document. You can refresh her recollection.
Apologize.
And ask her the question.
Sustained.
If you could just review that document and then we can go from there.
I recall
Okay.
this.
So what was the topic of
Hold
that?
on, just turn it over.
I can
I
actually.
want her to testify from her memory, not the document at this point.
So what was talked about in the conversations with Ms. Kurczewski?
The follow-up conversations, we discussed that there was no cause or manner of death yet determined. Toxicology results had not come back yet, so I didn't have anything to share. Our office was also reached out to by John Fryatt, if I'm pronouncing his name correctly, who self-identified.
Object, it's gonna call for hearsay.
Sustained. Also,
If you could just continue without talking about Mr. Fryatt, please.
Okay. Ms. Kurczewski called asking for cause and manner of death, in which I did not have anything to provide her.
Okay. Did she call you in October of 2018?
Yes.
Then did she call the medical examiner's office in January and February as well?
That sounds correct.
Okay. I don't have anything else, thank you.
all right, before cross, please go ahead and mark that exhibit, just for identification purposes.
Your Honor, we're gonna have that brought in, the copy that I had briefly made a note on it, so that's going to be marked as Exhibit 212 on a fresh copy though.
Exhibit 212, all right, thank you. All right, Attorney Kukler, will you be doing cross?
I will,
Go ahead.
if I could get my equipment to be proper. Good afternoon, is it Kooks?
Kukas.
Kookus? Okay, thanks. And what do you do for work at this time?
I manage a music lounge and event center.
Any particular reason you left the medical examiner's office?
No.
Just a change of career?
Yes.
When you received calls, you mentioned that Jessy called the office 3 times over the course of a few months, right?
That sounds correct.
That's not unusual for people to call the medical examiner's office to find out if you have any information, is it?
No, it's not.
People do it all the time.
Yes.
Yep. They want to know if you've determined cause and manner of death yet.
Correct.
You went to the scene of Lynn's death,
Yes.
and you made observations at the scene,
Yes.
and you collected evidence,
Yes.
and you took photographs.
Yes.
And then you also asked a police officer or a deputy sheriff to also take photographs?
I would not request that of the police department. They would do that on their own.
So you didn't do that here? You didn't ask them to take photographs?
No, I don't recall asking them to perform any particular duties.
And that's not something you would do. If you wanted a photograph, you take it yourself.
Correct.
And that's what you did here?
Yes.
Okay. And anything that you thought was significant, you took a photograph of?
Yes.
And anything that you thought was, should be gathered for evidence for your purposes, cause and manner of death, you took those things?
If it fell within our jurisdiction, yes.
For example, the medications, you gathered all those up?
I did.
And those were medications we saw on the tables to Lynn's right and to her left, is that right?
Yes.
And also medications you found on the floor?
Yes.
And did you go gather medications from her medicine chest?
I can't recall if it was medications from her chest specifically. I do believe there were some medications found in her purse in her bedroom that were also collected. So any medications that were prescription, I would have collected had I found them.
And you found the ones in her purse?
Yes.
And so you went and you looked through her purse?
Absolutely.
Is that where you found her driver's license?
The driver's license had already been procured by the police department upon my arrival, so they provided me with that.
You're not sure where they found it?
I could not testify to that.
And you looked into her medical history too, a little bit? And you saw medical paperwork right there at her residence?
I did.
And you noted that she had proctocolitis?
I don't recall making that determination.
Do you want to see your report?
Sure.
I'll bring up what we've marked as Exhibit 525.
I'm sorry, what was the number?
I think it's 525. Yes, 525, Your Honor.
Thank you.
Madam Clerk, will we show that to the witness?
It takes a moment, so be patient. It's up now.
All right. So I'm showing you, you see it's marked 525. You see the sticker on there at the bottom?
Mm-hmm.
Is that yes?
Yes,
And is this your report?
it is.
All right. I'm moving down to page 2. You have a subject, or I see your signature at the bottom of page 2. Is that your signature?
That is.
And I see on here confidential medical history. Did you input that information?
I did.
And so when you looked at her, does this refresh your recollection?
Yes, it looks like a list of diagnoses that her paperwork indicated.
So what diagnoses did you observe for Miss Hernan?
None of those diagnoses would have been observable in her deceased state.
Fair enough. What did you observe paperwork to show? What did you read on paperwork for diagnosis for Lynn Hernan?
The list of diagnoses that I have listed here would have been gathered from her medical paperwork.
Sure. Can you tell the jury what they are?
Listing off proctocolitis, hypertension, acute kidney failure, nausea with vomiting, hypercalcemia, hyponatremia,
It's okay.
abdominal pain, elevated liver function, metabolic acidosis, urinary retention, sinus tachycardia, Clostridium difficile, and renal failure.
And then there was also a note in her paperwork, wasn't there, about a palliative care encounter?
There was.
And when somebody is talking to somebody from palliative care, that's end-of-life care.
It's the stage right before that, yes.
And when somebody is possibly going to go into hospice.
Yes.
Do you recall what the paper was specifically that you read about the palliative care?
I believe it was a discharge summary, perhaps, from her last hospital visit.
And it's true she had just gotten out of the hospital a few days earlier, right?
I can't tell you how soon it was, but it was recent, yes.
And then we're moved for admission, Your Honor, of Exhibit 525 and request to publish this page.
Any objection?
I'm not objecting.
Exhibit 525 is received. Permission to publish is granted.
It takes a minute for things to pop up on screens. There we go.
Is it in the jury box yet? No. There's a little bit of a delay sometimes with that. Can be. Someone give me a thumbs up when you get it in the jury box as well. I promise it'll be there. It can be 30 seconds.
Still nothing in the jury. There we go.
Thank you. All right. Lots of thumbs up.
Thank you. All right. So this is what you were reading from, is that right?
Correct.
And it lists the paperwork, the medical diagnosis for Lynn that you observed on paperwork.
Mm-hmm. Yes.
Also lists the medications that you collected from the residents, true?
Yes.
Are you familiar with the purposes or side effects and things like that for medications, generally speaking?
Generally?
For example, you listed alprazolam. Is that the first one you listed?
It appears to be.
Okay. Well, you're looking at it, aren't you?
Yes, that's the first one I listed.
All right, and that's a sedative, isn't it?
I believe that's one of the side effects it can have, yes.
Isn't that why people are given it, for anxiety?
That's beyond my scope. I don't prescribe medications.
Okay, and would you agree that this particular medication can cause somebody as a side effect to become paranoid or to have suicidal ideations?
That's
I don't know how she can answer that. She just talked about her lack of knowledge
I'll
with this.
sustain it as to lack of foundation and qualifications.
So that's what I was asking you before, so I'm going to be clear. If I ask you questions about these medications, will you know? Will you know what they're for?
That's beyond my scope.
So you don't know what any of these are?
I might know what some of them are typically used for, but I could not testify as to why she was prescribed them or someone else might be.
You don't know whether any of them are dangerous or not dangerous? You don't have information?
Define dangerous or not dangerous.
Dangerous, something that somebody could, for example, take too many of and overdose, die.
There's a lot of medications that can be prescribed and over the counter that can happen with.
Well, I wasn't talking about over-the-counter medications. I'm talking about Lynn Hernan's confidential medications. Are you able to testify to any, whether if taken too many of can cause somebody to die from an overdose?
No, I think that's better.
Hold on.
Cause for speculation.
No, the question was asked, do you know? And so she may answer. Go ahead.
No, I think that's beyond my scope. It's for a doctor to determine whether or not something's an intoxication.
Okay. Now, when you were at the scene, well, I'm going to continue to go through some things in your report. You arrived at the scene at 18:10 hours.
Yes.
That's 6:10, right?
PM, correct.
6:10 p.m.
Attorney Kukler, do you still need the document up, or are you done with publishing what you needed to the jury?
For the moment, I'm done. Thank you. It could come down.
As you noticed, I like to bring the documents down and continue with the testimony if they're not needed, and I've done that for both sides, so go ahead.
Did you talk to Jessy at the scene?
No.
So all the information that you put in your report about what Jessy said, did that come from someone else?
Correct. If it's, it depends on the heading that's underneath there. So we do interview anybody that's there, including law enforcement. So they would have provided me with what she may have told them at scene to give a background, but then the information under non-confidential history, which outlines my conversation with Jessy, occurred via telephone after I arrived back to the office.
So my question for you is, in your report, when you put history of events, that Jessy stops by Lynn's home 2 to 3 times a day to assist her, that Lynn didn't seem herself lately, struggling with her mood, that Lynn, those statements,
Mm-hmm.
you got those from law enforcement?
Correct. History of events is my interview with law enforcement.
And so when the information that you put in here about Lynn ripping up medical bills or leaving her will out again, that came from law enforcement?
If it's in that same section, yes.
And you've reviewed your report before testifying here?
Yes.
I would like to finish the question first. You reviewed your report before testifying here?
Yes.
So you know that that's in your report?
I know it's in that section, as well as I believe the second section under non-confidential history.
And part of your history of events is that Lynn has a history of abusing prescription medication.
I can't recall. I can't say I memorized my report.
Okay, that's all right. Judge, we'd like to show it to the witness.
Perfect.
Presume reviewing your report will refresh your recollection?
Yes, please.
All right, go ahead.
I'm just going to show it to you, not to the jury. If you would review what's on your screen, history of events, read it to yourself and let me know once you've read that paragraph. take that down from the witness. Did that refresh your recollection?
It did.
So is it accurate that you have in your report that Lynn has a history of abusing prescription medications?
That was information that the police gave me.
I asked you if that's in your report.
It is in my report.
And in your report, did you also indicate that she, meaning Lynn, crushes her pills due to issues swallowing?
Yes.
That Lynn has been unwell for several years?
Yes.
That doctors have been unable to diagnose her with a definitive illness?
Correct.
And that when Jessy was asked by police if she thought Lynn was suicidal, she was unsure?
Correct.
You indicated in your report that it was a tidy, clean condo that
Yeah.
Lynn lived in.
Yes.
How many bedrooms in that condo?
I believe there was one bedroom.
How many bathrooms?
I believe there was one bathroom.
And you said, I think, that you went in the bedroom because that's where you found the prescription in Lynn's purse,
Correct.
or some prescriptions.
Yes.
How many were in her purse?
I don't recall.
Do you know which ones specifically you found in her purse?
I do not.
Is there any way we can look at the medication log and determine which were in her purse and which were somewhere else?
It may say in the log where I found them specifically, but that would be the only indication.
Okay. And the observations you made at the scene were that there were 3 tables to Lynn's left cluttered with multiple prescription medications.
Yes.
And I'm going to bring up, I'd like to show the photographs to the witness that have already been admitted into evidence.
So you're talking about
State's
exhibits 7 through 20 and 130 and 131.
No, I thought the state started showing, did they not show the scene photos?
Yes, those are exhibits 7 through 20 and 130 and 131.
I see. Okay, well then, I will start there. Thank you, Judge.
Sure.
Okay,
Would you like to publish while you're doing
I
this as
would.
well?
I'd like to show them to the jury and talk about each photo with the witness.
Go ahead.
So I am showing you what's marked and previously admitted as Exhibit 7. Do you have that in front of you?
I do.
And that's how you saw Lynn when you arrived at the scene, is that right?
Correct.
And and you said that you take a look at things to observe the scene and make sure that there's no evidence that a person's been moved. And as you looked at Lynn, it didn't look like she had been moved. True?
That's correct.
And that's the TV, and you just wanted us to see that because you wanted to see that she was facing the TV and she could also see who was coming in and out of the condominium. Is that right?
That's fair to say.
And I wish I could do this easier.
If you want to have us stop publishing for a moment, you could open each of them up and then click from one to the next.
Oh, I see.
Would you like to do that?
How do I do that?
Open each one in, I think you're in Adobe, and then you click the tabs on top.
Okay.
Why
we'll
don't
do
we
that.
we'll stop publishing for a moment.
What do I do?
So you know how you were going back to the
Yes, to the main
the
screen.
file?
Right.
Yes. you should be able to highlight using the control key each exhibit you want to open, and if it works, they'll all open separate tabs, but
All right, that sounds,
you have to simultaneously, not that way, hit control and then each one, but it can't do where it's at the yeah, there you go.
well, I won't be able to do that apparently, so we'll just keep doing it the way I'm doing it.
Problem.
I'm showing you what's marked as Exhibit 10 now,
All right, we'll republish. There you go.
and it, do you see that?
Yep, it's on my screen now.
Okay, great. And there we can see some pills on the floor, is that right?
Yes.
Some that seem to have spilled out of bottles, right?
Yes, perhaps.
Or
I can't testify to how they got there, but there are capsules and tablets on the floor.
and we can see an open prescription bottle on the floor too, can't we?
Yep,
It's missing the lid.
it is.
And we see an ashtray with one finished cigarette and one ready to go, or maybe was just smoked for a minute.
Appears so, yes.
And there's lighters there, appears that Lynn smoked cigarettes.
Yes.
Did you take pictures of her cigarette or her packs of cigarettes?
I don't believe I did.
And now the pills are in a little different position now on that same table. Did you move them to put them in like a semicircle so you could get a better picture of them?
Yes, I'm trying to show the names of the medications and her name on each bottle.
And so when we see what's marked Exhibit 11, that's not how you found them, that's how you wanted to demonstrate them.
That was to make them more readable. The way they were found was in the original first few photos.
Right. This is how you put them up for display.
Correct.
Okay. And this is another table to the right side of Lynn that you took a picture of because it shows more pill bottles.
Correct.
One that doesn't have a lid on it, true?
That's true.
And this is Exhibit 12.
And that was 12. I'll confirm that for you.
And Exhibit 13, is that just a close-up of the same thing?
Yes.
And you took a close-up for what reason on this picture?
I think I'm just trying to see if I can get the names to be made out in the photograph. Maybe I thought the first one came out a little blurry.
And when you looked at all the pill bottles here, all the pill bottles were in the name of Lynn Hernan, right?
As I recall, yes.
If you had seen pill bottles for someone else, you would have noted it.
Yes.
That would have been a big red flag, right?
I would have noted that.
All right. And let's try again. And Exhibit 14, this is a close-up of Lynn. She has a chain around her neck, right?
Yes.
And you later on took a closer look at that and determined those are her father's dog tags, right?
Yes.
From the military.
Yeah.
Which one has? I'm going to show you Exhibit 29.
This isn't in evidence.
Let's take it off the screen so she can identify it.
Can you take a look at Exhibit 29?
Oh, it'll take a moment.
And I would note, Your Honor, this is not a photo
Well,
that she took.
She can be questioned about it. She was at the scene. Go ahead.
Okay. Can you see Exhibit 29 in front of you?
I can.
Is this, whether you took this photo or not, is this how you remember seeing Lynn in the scene on October 3rd, 2018?
It is.
Now, look at that table to Lynn's left. I know you testified earlier that there were no eye drops at the scene, but do you in fact, now that you take a close look at that table to her left, see a bottle of eye drops next to the toilet paper?
I see what could be eye drops. I can't say for certain what those are.
Okay. I move for admission of Exhibit 29 and ask to publish.
Any objection?
I am objecting. This is not a photo that this witness took.
Overruled. Exhibit 29 is received. Permission to publish is granted.
Can everybody see Exhibit 29 now? No? Okay. Can see it now? Okay. And so this is how you remember the scene. Now that you look at this is accurate.
It appears.
And you didn't make a note of the drops, whatever those drops were, anywhere in your report, true?
That's true.
And would it be fair to say that okay, thank you.
You're welcome.
Would it be fair to say that you were not thinking about eye drops when you were at this house on October 3rd, 2018?
That's fair.
And so if there were eye drops around the house, they probably wouldn't have caught your attention.
If there was 1 or 2 bottles like anyone else's house, no, they would not have caught my attention.
And in fact, this didn't catch your attention because until now you didn't really notice it.
Correct.
But those do look like eye drops, do they not?
Could be nasal spray. I really can't say what that is.
Okay. We can take that down, Judge, or Madam Clerk. Now, I didn't see any photographs of wastebaskets. Did you take any?
Not that I recall.
You did make a note that you saw liquor bottles in a wastebasket,
Yes,
but you didn't photograph them.
I did not.
Do you remember if they were vodka?
I do not.
You couldn't tell us today what kind of liquor they were.
No.
Which wastebasket, was it in the kitchen where you saw the liquor bottles?
I believe it was the kitchen, yes.
Do you have any knowledge as you sit here today of what else was in that wastebasket?
Nothing that I recall.
What about in the bathroom wastebasket?
Nothing that caught my attention.
In the wastebasket in the living room, do you have any recollection of what was in that?
Nothing that caught my attention.
Because again, really you were focused on medications, mostly.
I was focused on everything in the scene, but unless something appeared out of place, I wouldn't have necessarily documented it.
You said that you, did you bring a medical bag with you to the scene? Did you bring a medical bag with you to the scene?
I brought my backpack. I don't know if I would call it a medical bag.
And that's what you take to scenes, your backpack?
Yes, my scene bag, yes.
Okay, and what do you have in your scene bag?
Various items, gloves. There's probably a pocket knife would have been in it, a tape measure, additional forms, documents in case I needed someone to fill something out, extra paper, tape in case, paper bags that we used often for gunshot wounds.
Do you carry a thermometer with you?
We carry an ear thermometer that we use for babies.
Well, because one of the things you said to the state was that one of the things you do at the scene is you take a temperature.
Of the room, yes. There would have been a room thermometer, not a body thermometer.
Okay, the only body temperature item you have is an ear thermometer.
Yes.
And you didn't take Lynn's temperature.
We typically do not take temperatures of decedents, no.
and again, I'm not really asking generally, I'm just asking about this case.
No, I did not take her body temperature.
Okay. You did take a look at whether or not you started to see, I thought you said rigor, but isn't it rigor mortis?
There's debate on the pronunciation.
Okay, so rigor mortis or rigor mortis, however you want to pronounce it, you took a look at that, right?
I did.
And that's where muscles on a body start to stiffen up, right?
Yes.
And you noted that rigor was present in her jaw and her neck
That sounds correct.
and in her upper extremities.
That sounds correct.
And there was no rigor yet in her lower extremities or in her stomach area, true?
There wouldn't have been, I don't think we would document rigor in her stomach, but, and not in her lower extremities, no.
I guess I should have been precise, the trunk. You look at the trunk, don't you?
Yes.
It wasn't yet in her trunk or her lower extremities.
No, I don't recall it being in her hips or her legs.
Okay. And you said you're trained in medical death scene investigation. And as part of that, have you been trained in doing that with the Spitz and Fisher? Are you familiar with their teachings in that?
No, I don't recall a specific textbook used.
When you've studied in your death scene investigation, in your training though, and in looking at rigor, you know, do you not, that starts to set in 1 to 2 hours after death.
That's a good average.
Now, you arrived at the house at 6:10.
Yes.
When rigor starts in the face and the jaw, ultimately moving into the trunk, into the lower extremities, that whole process is usually complete in 6, maybe 8 hours. True?
There's a pretty wide range when it comes to looking at rigor mortis. Everything from the temperature of the room, the clothing the decedent is wearing, what kind of material they're on, if they're covered with a blanket, all of those things have to be factored in. It starts with smaller muscles and then goes to the larger muscles, so I wouldn't say that it goes to the trunk prior to the legs.
It could go to the legs and then the trunk.
It could.
Sure. And of course, it can vary if you're, for instance, a person is outside in a cold or in a cold area, for example, it might not progress at sort of the normal fashion.
Absolutely.
But you did take the temperature in her condo, it was 79 degrees.
It was.
Okay. So it wasn't cold in her condo,
No, I'd say that's a bit warm.
depending on a person's health,
Yeah.
right?
Yes.
People who sit around a lot and aren't moving a lot get colder.
Very often.
So if we were to look at the rigor that was in Lynn, in her jaw, and her neck, you took a look at her sometime between 6:10 and 6:40.
Yes.
Because it said it took you about a half an hour to do everything that you needed to do at the scene.
Yes.
And so at the point that you saw her, would you agree that the rigor is probably somewhere between 2 and 4 hours?
That's very difficult to put any sort of time frame on. We don't typically give a time frame or an estimated time of actual death.
You wouldn't disagree with literature that indicates that the typical rigor is complete in the lower extremities in somewhere in the 6 to 8 hour range.
I imagine that's what the literature says. It was my job to observe the rigor, and how that was interpreted by the doctor is beyond my scope.
Okay. Have you done any research in that area at all, or any study in that area?
Not particular academic study, no.
You saw water bottles at the scene, or at least a water bottle. You didn't collect that, did you?
No.
How many water bottles were at Lynn's home?
I don't recall.
Do you know if there were any on the kitchen counter?
I don't recall off the top of my head.
When you took pictures of different parts of rooms, you only took limited pictures in rooms, right? You didn't take an overview of all the rooms, like the bedroom.
That's fair.
The bathroom. You didn't do that.
Correct.
At the time, you were focused on medications, it seems like.
I was focused on the decedent and what was surrounding her.
And any medications that you saw elsewhere, you focused on.
Yes, we do typically focus on medications. That's part of our protocol.
You said that Lynn was wearing no bottoms. Is that right?
Correct.
But she had a blanket over her.
Correct.
And she had an absorbent pad of some sort underneath her.
Yes.
Did you take any pictures of the toilet in the bathroom?
I did not.
You learned when you got non-confidential history in your report that, in fact, Lynn was released from the hospital last Friday. Do you remember that?
I recall she had been in the hospital recently.
Do you remember that you indicated in your report she had just been released on Friday?
Yes.
And you indicated that it was recommended that she enter an inpatient rehabilitation facility for physical therapy, but she refused.
Correct.
She also declined recommendation for home health care.
That's what I was told?
She had an appointment yesterday for blood work, but refused to go.
That's what I was told.
Seems like she was pushing back her medical appointments.
That's what I was informed.
And with the non-confidential history, was that also from law enforcement?
No non-confidential history would have come from Ms. Kurczewski.
Okay. And so Ms. Kurczewski told you that Lynn was tired of being ill,
Yes.
that she was afraid of being declared incompetent and put in a nursing home.
Yes.
What you asked her about suicide, Jesse, was uncertain.
Yes.
But she did admit she thinks Lynn takes too many pills,
Yes.
including pain pills and sleeping medication.
That's what she told me.
And that Jesse told you it was common for Lynn to crush medications because of her problem swallowing.
That's what she told me.
Even though you took medications out of Lynn's purse, you didn't take a photograph of the purse.
I don't believe I did.
I don't see it in the photographs.
Correct. So I don't believe I did.
The state said that, or strike that. Did you see, you indicated in your report that you saw some crushed medications on Lynn's chest.
There was something crushed on her chest, yes.
Something crushed on her chest, and some kind of pill, looked like part of a pill in her mouth.
Appeared to be some sort of tablet.
You didn't say anything in here about pills in her hair.
No, I don't recall anything in her hair.
If you had seen anything like that in your hair, you would have made a note of it.
I would have.
And again, you noted that she was wearing the dog tag, which bore the name Robert Wallace Hernan.
Yes,
And you learned that was her father,
yes,
her deceased father.
correct.
You learned that that you saw and you took a picture of her will, a power of attorney or living will. Is that right?
Yes,
And that's already been admitted as Exhibit 19, I think. Let me just be sure about that.
Attorney Kugler, I apologize for the interruption, but I need to take a comfort break before we continue. Any of my jurors need to as well. We'll try to at least, yeah, they're shaking their heads. I'm gonna take a pause and then
Okay.
before I bring them back out, we'll talk about how much time with this witness and I'll make a
Okay.
decision on if we're gonna break. All right. All rise for the jury, please. And jury will be brought out momentarily. Yeah, but I write on them. Because you're my copy. You should have a second copy.
Okay, great.
I just looking for numbers like number 7 through whatever in that box.
I wrote on mine, notes or she needs
It goes up to like 6 and then it jumps to 30 or something. Right now, some caps being used and it won't let me take them off the flashlight.
All rise for the jury.
It's also over the course of the last 2 months decided that anything that looks like a form is a problem.
Oh. Like it's a fillable? That's weird. Thank you. Please be seated. And Attorney Kukler, you may continue with your cross.
I'd like to, for the last few questions, I'm almost done, Your Honor. I'd just like to share my screen and show this witness some other exhibits that have already been received into evidence.
Sure, go ahead.
So I'm showing you what's already been received as Exhibit 10. Do you see that in front of you?
I do.
Is that being shown to the jury?
Not yet, Madam Clerk. You can publish.
I see on the floor. Oh, how do you know?
Is the bailiff is shaking her
We're good now.
Okay, showing you what's marked as and received as Exhibit 10. Do you see the spoon on the floor?
I do.
You didn't collect that spoon, true?
That's true.
You didn't take the pee pad that she was sitting on, did you?
No.
We saw previously the living will that you took a photograph of as Exhibit 17. Do you remember testifying to that earlier?
Yes.
And that is a power of living will naming Jessy Kurczewski as her power. Is that right?
Yes.
And then I want to show you,
Sorry,
Your
what
Honor,
number was that?
that was 17.
Thank you.
And then if you take it down, because I need to show her something that hasn't been admitted yet. I want to show you what we have marked as Exhibit 543. Can you see that yet?
Not yet.
Okay. Do you see Exhibit 543 yet?
No.
Okay.
It's on my screen.
All right. When you were talking about substance on a plate, is this what we were talking about?
Yes, that appears to be the same plate.
And that's what, and you recognize this as being from this scene that we've been talking about here today?
From the scene, yes.
Your Honor, I'm going to move for admission of photograph 543 and ask to publish.
Any objection?
I'm just briefly looking through all these photos because there's about 30 photos that they're trying to admit. That's part of one of their exhibits.
Is there any objection to the court receiving it?
That's why I'm analyzing all 30 to make sure that there's no objection.
Is this a single photo at this point?
There's 30 photos as part of this exhibit,
That was it.
and they're trying to admit all of it.
They're all scene photos that were taken at the scene. Received from the state.
All right, I didn't know that there are 30 photos within 543. So are you going to seek all of them at this time?
I was really only looking for this particular photo, but I see it as part of a larger exhibit. They're all photos from the state, so yes, I would move for admission of 543. They're all the same photos that we've been looking at. All received from the state.
Can you just go page by page so I can see those?
You bet.
Thank you.
Let me know if I'm going too fast.
You're okay.
Oops. That's the end.
Obviously, some of those are duplicates to exhibits that are already in evidence. As to the ones that are not duplicates, what's the state's position?
I'm not per se objecting to the admission of this exhibit. I think she's only trying to get in the one photo or publish.
Well, she's now offered all of them. So
Right. She's also trying to publish the one here, which I am not opposed to publishing that. I just want to make sure that she doesn't publish
Well,
the
is there an
victim's medical records.
objection to any of this exhibit?
No.
Then exhibit 543 in its entirety is received.
Thank you. Asking to publish one page from it.
All right, and it looks like that's page 13 of 543, if I'm reading the side correctly.
You are right.
All right,
Page 13.
permission to publish granted. All right, we have it in the jury box
We
as
do,
well as
okay.
the monitors.
All right, and this is also represents another part of the scene when you arrived at Lynn's home, right?
Correct.
And we can see crushed substance on this plate,
Yes.
and you didn't collect this plate or this substance.
No.
And there's crushed pills or broken pills and maybe whole pills, look like pills on the floor, right?
Yes.
Did you collect all of those products from the floor?
The whole pills, I don't think I collected every fragment.
Not the little pieces?
No, I can't say that I got every little piece.
Okay. Thank you. That's all I have for this witness, Your
All
Honor.
right, thank you. You can
Take down the exhibit.
take down. Any redirect?
I don't have any redirect, thank you.
All right, thank you. You may step down.
I'll be asking that she be released from her subpoena.
Any objection?
No.
All right, she may be released. All right, ladies and gentlemen of the jury, I will be reading what I've read to you previously, but it is important that you keep in mind the rules that govern you and not deliberating and not researching or looking through or reviewing any type of news reports, etc. So I'll just read this to you. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging, or social networking sites to send or receive any information about this case or your experience as a juror. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. That includes, of course, any streamed coverage that one could find even as you go home tonight.